Welcome to the June 11th, 2025 Enforcement and Compounding meeting. My name is Maria Serpa, chairperson of the committee. Before we convene, I would like to remind everyone present that the board is a consumer protection agency charged with administering and enforcing pharmacy law. Where protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. As I facilitate this meeting, I will announce when we are accepting public comment. I have advised the meeting moderator to allot 3 minutes to each individual providing comments. Throughout the meeting and at appropriate times, we will begin with public comments for individuals attending in person, followed by public comment by individuals participating via WebEx. This approach is necessary to facilitate the meeting. Before we get started, I'd like to ask staff moderating the meeting to provide general instructions on the process for providing public comment via WebEx.
Thank you. This is the moderator, and this is an example of the slide that I will show during the public comment section. We ask if anyone would like to make a comment that they click on the hand icon that is behind the 3-dot other options if you're on a mobile device. If you're on a computer, then it's at the bottom row of your WebEx screen. And if you're a call-in user, you can press *3 to raise your hand. As stated, each speaker will have 3 minutes with a 10-second warning, and we ask speakers to only speak once per agenda item. And at the end of the public comment period, we will close that. I believe that covers everything. Thank you.
Great, thank you. I would now like to take a roll call to establish a quorum. Renee Barker.
Present.
Jeff Hughes is not attending today. Sung Oh.
I'm here.
Ricardo Sanchez is not able to attend today. Nicole Tebow. That's interesting. Sorry.
Licensee member present.
Thank you. A quorum has been established. I ask everyone participating today to be respectful of the work before the committee. We encourage participation by members of the public throughout our meetings at appropriate times. The committee respectfully requests that when comments are provided, they are done in a professional manner consistent with how the committee conducts its business. Before we move on to the next agenda item, I'd like to remind committee members participating via WebEx to please remain visible on camera throughout the open portion of today's meeting. Members, if you need to temporarily turn off your camera due to challenges with internet connectivity, please remember to announce the reason for your non-appearance when you turn off your camera. Moving on, agenda item 2, public comment on items not on the agenda and agenda items for future meetings. I will now ask the moderator to open the line for individuals to provide the opportunity for public comment on items not on the agenda. You are not required to identify yourself, but may do so. I'd like to remind everyone that the committee cannot take action on these items except to decide whether to place an item on a future agenda. Accordingly, if your comments pertain to an item on today's agenda, please save your comments for the public comment period specific to that agendized item. Members, following public comment for this agenda item, I will ask you to comment on what, if any, items should be placed on a future agenda. As a reminder, this agenda item is not intended to be a discussion, rather an opportunity for members of the committee and members of the public to request consideration of an item for future placement on an agenda, at which time discussion will occur. Are there any members of the public in Sacramento? I don't see anybody on the camera, but just confirming.
No members of the public in Sacramento.
Okay. If someone should arrive, just let us know. Otherwise, I think I'm going to skip asking about Sacramento throughout the meeting. Is that okay?
Yes.
Great, thank you. Moderator, we're ready for public comment for items not on the agenda from individuals participating via WebEx.
Thank you. If anyone would like to make a comment, as I do see one raised hand, you may click on the hand icon at the bottom of your WebEx screen, or it may be behind the 3-dot other options if you're on a mobile device, and our call-in users may press *3 to raise their hands. Each speaker will have 3 minutes with a 10-second warning. I do see a raised hand from Vincent Shires, and Vincent, I'm going to send you a request to unmute your mic, and once you're unmuted, you'll have 3 minutes. Go ahead.
Can you hear me?
Yes.
Perfect. I humbly request that the Board of Pharmacists or this committee would consider when it comes to settlements with community pharmacies for a more transparent or how they come to a settlement. Specifically, recently I was subpoenaed for citation number, I can't remember at the moment, for regarding quotas for against CBS 2022-99937. And I was subpoenaed to testify, and it appears the board has settled for a penalty of 70%
Excuse me,
lower.
sir.
Mhm.
I am so sorry. This is Corinne Gardner. I'm counsel to the pharmacy board.
Mhm.
I respectfully ask that if you have comments pertaining to an open investigation, you not make those at this time because we do need to be careful
I
to
assume when
avoid
the board,
ex parte communications.
I assume since the email said that it was settled, that it was no longer open.
Yeah, if I could just ask that your comments be kept general and not identify any specific parties.
Sure. Sure. I respectfully request that the board would consider having a more transparent either option or explanation in the future regarding settlements for community pharmacies after they're settled, of course. Thank you.
Thank you.
Thank you.
And I do not see any other raised hands. Shall I close that public comment feature?
Yes, thank you.
You're welcome.
Before we move on, Corinne, since you were on Echo, maybe you can explain why we cannot talk about specific cases in the committee?
Sure. Okay, the echo is gone. Thank you. Yeah, so the concern is that we need to avoid ex parte communications, which is where there are discussions going on that are outside where both parties and the judge are not there.
Okay, thank you. Okay, members, I don't believe we can bring that item specifically up for the agenda, but I did want to bring it back to you in case you had any questions regarding the disciplinary process. We will have a presentation today about disciplinary process, and so maybe you could ask a general question at that time. But other than that, did you have any items that you would like to place on a future agenda? Okay, thank you. Moving on to agenda item 3, approval of draft minutes for March 27th, 2025 committee meeting. Members, attachment 1 to the meeting materials includes a copy of the draft minutes from the March 27th, 2025 meeting. Do you have any questions or comments on the draft minutes? I would also entertain a motion should you believe such action is appropriate. Members?
I can make the motion. This is Song, Chair Serpa, to approve the minutes.
Thank you. Is there a second?
I can second that.
Thank you, Renee. With a motion and second on the floor, I now open the discussion for public comment on the draft minutes. I saw someone walking in Sacramento. Is there still nobody in Sacramento?
There is no one in Sacramento from the public.
Thank you. So we're ready for public comment for individuals participating via WebEx.
This is the moderator, and if anyone would like to make a comment, you may look for the hand icon at the bottom of your WebEx screen or behind your other options. And if you do not see that and you're on a mobile device, you may look behind the 3 other options. Call-in users can press *3 to raise their hand. Are there any comments on the motion or the minutes? I do not see any requests for comment. Shall I close that public comment feature?
Yes, thank you.
You're welcome.
Maria, I apologize. This is Anne. Moderator Anne, I just wanted to call out that some of the communications that normally don't show on your display, we can see some of your screen, including like some apps and things like that. So just wanted to make sure. I know that there's been an update to the system, so wanted to make sure that you were aware. Thank you.
Thank you so much. I will verify or attempt to verify that we are sharing the PowerPoint and not my screen. And that's an interesting aspect to be aware of. Thank you for letting me know.
Okay. Hearing no public comment, we're ready for a roll call vote. Renee Barker,
Yes.
thank you. Sung Oh,
Yes.
thank you. Nicole Tebow,
Yes.
and I vote yes, motion passes. Next item is agenda item 4, annual presentation of the board's inspection program. Members, strategic objective 2.3 of the board's strategic plan calls for completion of routine inspections of all licensed pharmacies at least every 4 years to proactively assess pharmacy operations and educate licensees. On an annual basis, the committee receives a presentation providing summary information detailing accomplishments towards this objective. I would like to commend board staff for their significant efforts to meet the board's strategic goal. I want to announce that there's been a change in presenters for the inspection presentation this year. Julie Ansell, Deputy Executive Officer, will be giving the presentation. Julie, the floor is yours.
Good morning, Chair Serpa and board members. Nice to be here today. Hope everyone is doing well. Thank you for the opportunity to be able to provide an update on the board's inspection program and the progress we've made thus far this fiscal year. I'd like to take a moment to acknowledge and thank all the supervising inspectors and inspectors for their hard work throughout the year in completing these inspections. Next slide. So why do we inspect? Simply put, it's really consumer protection. That's, of course, our highest priority. It's always consumer protection. And although some people may associate consumer protection with enforcement actions or licensee discipline, that is one key component of consumer protection, but it isn't the only one. And to that end, inspections really provide a significant opportunity for education as part of our consumer protection process. And in fact, the board did establish a policy goal to inspect all pharmacies every 4 years. And these inspections really provide board inspectors with the opportunity to observe, evaluate for compliance, and it also provides an important educational opportunity for inspectors to provide guidance and answer questions for licensees. The board has several resources available to assist to prepare for an inspection when the inspector arrives at a pharmacy. Some of our resources include our Ask Inspector program, where you can contact the board by phone or email and ask about pharmacy laws, regulations, and compliance questions. We also have a video online on how to prepare for a board inspection. It's a recorded presentation by a board inspector on how to prepare. We also have a board brochure titled Pharmacy Inspections that reviews what to expect during a pharmacy inspection. We always have updates in our script newsletter. And then finally, our board self-assessment, which is really the ultimate resource for a pharmacist in a pharmacy. And it's really a roadmap to compliance. And that self-assessment is something that needs to be completed by all pharmacists in charge before July 1st of every odd numbered year. Next slide, please. So as part of the inspection process, board inspectors will observe and look for some typical items within the pharmacy. They look to see if consultation is being provided. They look for the notice to consumer poster, point to your language sign, and the pharmacy permit to ensure that they are all posted. They'll check to see if staff name tags are visible and staffing ratios are being followed. And in general, the board inspector will observe and review what is happening within the pharmacy. Next slide, please. During the inspection, specific documents will be reviewed and inspectors will confirm compliance with various aspects of pharmacy law. They'll look for a current self-assessment completed by the PIC, compliance with cures reporting, and if the pharmacy is enrolled in board subscriber alerts. The inspector will review policies and procedures and the pharmacy's current quality assurance policy. Next slide, please. So what is inspected during an inspection? The inspector will assess the physical state of the pharmacy and check items such as the will call area. Is protected health information visible to the public in the will call area? The shelving in the pharmacy, looking at expiration date, expired medication or expired ingredients in the pharmacy or on the shelves. Are the shelves clean? Is the overall pharmacy clean and orderly and neat? Or is it cluttered? Again, what is the physical state of the pharmacy? Next slide, please. As I mentioned earlier, these inspections really provide a great opportunity for education, and the board welcomes questions from licensees during an inspection. As part of all inspections, there's an expectation that our inspectors will provide helpful and standard educational information to licensees. Typically, inspectors will review some current educational topics with licensees. These topics will vary depending on new laws and regs being implemented, as well as trends in pharmacy practice. Next slide, please. This slide provides a 5-year history of our total annual inspections completed. And for the current fiscal year, our inspectors have completed 2,833 inspections as of May 15th, 2025. Board has averaged approximately 2,950 inspections annually over the past 5 years. And I think, our data is through March 15th. We would still have 6 weeks to add throughout our fiscal year. So I think this average number will increase when we pull in those last 6 weeks of the year. When we run our numbers for data like this, we have to do it a couple weeks ahead of time before a meeting, just the way our systems work. So just calling that out. But I think in capturing that next 6 weeks of inspection data, we'll come up to our average, which is about 2,950, close to 3,000, I'm expecting. Next slide, please. So here we broke down inspections by visit types. Inspectors may be prompted to inspect a pharmacy for a few reasons. They may be visiting a pharmacy for a routine inspection, and it may be triggered by a complaint. The pharmacy or staff may be on probation, or the inspector may be visiting a pharmacy for an annual compounding inspection, but then we're also going to do the pharmacy routine inspection as well. And as you can see, most board inspections by these numbers were completed in pharmacies. That's our largest site licensing population. Sterile compounding pharmacies, which require a mandated renewal inspection, that accounts for almost 30% of the board's total inspections annually. Next slide, please. As we continue to break down by, sorry. I hit the wrong button, I apologize. As I continue to break down our inspections by visit type, this slide shows the number of automated drug delivery systems that were inspected this fiscal year, and then a handful of other types of inspections conducted. And again, our total inspections completed this year was 2,833 through May 15th, 2025. Next slide, please. So when it comes to routine inspections, the board, again, it has a goal to conduct a routine inspection every pharmacy every 4 years. So this slide shows that the board conducted 1,464 routines in fiscal year 24-25 as of May 15th, 2025. And this is approximately 25% of our total licensed pharmacy population. Of the 1,464 routine inspections, 1,135 of those were true routine inspections, meaning that the inspector visited that location for the sole purpose of conducting a routine inspection of that specific pharmacy. Another 329 routines were conducted while the inspector was at the pharmacy for a probation visit, a complaint investigation, or a compounding renewal. Next slide, please. This slide breaks down the outcome of our routine inspections conducted during the current fiscal year. And of the 1,135 routine inspections, approximately 46% or 527 pharmacies had no violations when we went in for a routine inspection. Another 580 were issued corrections and 75 received written notices. And you'll see that number 1,135, it's not going to tally exactly with those three numbers directly under it, because some pharmacies may receive both a correction and a written notice during an inspection visit. They may receive multiple. They may receive one. They may receive one correction and one written notice. So it's just not going to tally exactly. And here we also see routines conducted during a complaint visit and the outcome of the inspection. About 45% or 109 pharmacies inspected conducting during a complaint visit received no violations. Another 106 pharmacies received corrections, and then 47 received written notice. Again, pharmacies may receive both a correction and a written notice during the same visit. Next slide, please. Continuing with our inspection outcomes for our probation visits, here we see 78% or 59 pharmacies were issued no violations, and then another 17 received corrections during their probation visit. Our compounding visits of pharmacies revealed no violations issued during these inspections. Next slide, please. So this year, we decided to look at the top corrections on routine inspections by breaking it up in between chain pharmacies and non-chain pharmacies. So this chain shows the top corrections during routine inspections. The left-hand side is the chain pharmacy setting, and then the right-hand side is the non-chain pharmacy setting. And for chains, some of the top corrections involved pharmacy operations, the display of license, and vaccine administration. For non-chains, top corrections included inventory reconciliation, consultation, and again, pharmacy operations and securities. One of the things I wanted to highlight is the concept of violation and how one violation can have a spectrum of behavior, a spectrum of non-compliance, depending on the behavior that is observed by the inspector. So one of the ones that I think is a great example is California Code of Regulations 1714, which is standards and operational standards and securities. I think it's a great example of a spectrum of behavior that may be observed. So within that code, we can see multiple things. We can see things like dirty dishes in the sink, a dirty sink, possibly mineral deposits, no hot running water, just a dirty pharmacy, dusty shelves, disorder. That all might be on one end of the spectrum, right? That's fixable. But also within operational standards and securities, we may notice something where like someone other than the pharmacist has possession of the key to the pharmacy. So someone is getting into the pharmacy at times where there is no pharmacist present. And then another behavior or thing that we observe under 1714 could be a rodent infestation. So here we have one violation, CCR 1714, but we have different behaviors yielding very different outcomes when we make a decision on a case investigation. And also the potential for harm and the impact for patients is vastly different. Next slide, please. So this slide reveals the top written notices during a routine inspection in chain pharmacy settings and non-chains. For chains, one of the tops was standards and security, again, consultation being one of them, and then the self-assessment, whether it's either not available at all, nobody's completed it, it's partially completed, or possibly someone's coming into the pharmacy, a new PPIC, and they're not completing it within that 30-day mark. For non-chains, we observed, again, inventory reconciliation, operational standards and securities, and unprofessional conduct as some of the top violations. Next slide, please. So one of the things that the board really continues to focus on is the importance of consultation in pharmacy practice. And as we saw in the last slide, some of the top corrections and violations Consultation is one of them. It's one of the non-compliant issues that we do witness when we go in for a routine inspection. So this slide reveals that across our routine inspections, we saw 160 instances at pharmacies where there was an issue with patient consultation. And I wanted to kind of break that down and explain that. So again, it's a reminder, just like operational standards and security, it's kind of on a spectrum, right? We see varying behaviors. 9 out of these 160 inspections, the inspector actually witnessed that either consultation wasn't being provided or that staff was screening for consultation. In another 68 inspections, it was discovered that the pharmacy has a mail order or a delivery of prescriptions, but they're not providing that written notice of the right to consultation to the patient. And then in 83 instances, the notice of the right to consultation for mail order or delivery, it didn't fully comply with the elements required in the regulation. It was missing a key element, whether it was the phone number or the hours of operation were inadequate, but just again, not fully complying with that specific requirement. Next slide, please. So in summary, once again, I really think that staff just did a great job this year, completing all the assigned inspections, routine inspections this fiscal year. And I'm very pleased to report that every pharmacy licensed for more than 4 years has received a routine inspection. We are very focused on this at the board. I think I can see clapping little faces. Thank you. Last week, we assigned over 1,550 routine inspections to inspectors. We're trying to get a jump on fiscal year 25-26 so we can continue to achieve that goal, ongoing goal to inspect a pharmacy within 4 years. That concludes my presentation. I appreciate your time and happy to answer any questions. Thank you.
Thank you very much, Julie. This is great information. I truly appreciate the efforts of field staff to perform the inspections and to actualize our goal of every 4 years. Members, as you may remember, we heard comments from members of the public at a previous board meeting discussing hospital pharmacies. They indicated that it would be helpful to provide inspection data divided by pharmacy license category. It was too late to provide this information this year, but I would like to request that next year's presentation, that inspection data be broken up by license category. This granular information may be more informative to licensees. Members, do you have any questions or comments for Julie? I see everyone's hand, but pick up if I don't see them.
Sorry, this is Nicole. I had a quick question. I wanted to know if you could, Julie, if you could expand a little bit on violation versus written notice. Like, when do you get which one? Like, what triggers which one, and like, what does that mean overall?
So a written note, I'm kind of using them interchangeably. I apologize. A written notice is a violation. A correction is more like a warning, right? In a correction, there is a violation of law, but we're not noting it. We're not taking any action. We're just kind of chatting with the licensee, putting it down on the inspection report and issuing it as a correction. When I say violation and written notice means we're actually, documenting the violation and then making possibly some kind of decision in terms of moving forward with an investigation or a written report. Because the belief is that when we're documenting a written notice, that is more of an egregious situation, and probably might be something that can't just be quickly corrected and needs to have a little bit more attention. Does that make sense?
That does make sense. And I think maybe as you're talking about this, it might be helpful to, explain this maybe through the public education committee. I think people get confused sometimes about that sometimes the board will tell you you need to work on something, but that's not truly a violation that's being documented, that's being held for later. So maybe that's something we want to look at in that committee. Thank you.
Yeah, you're kind of saying to parse out what the, what is the correction, what does violation mean, and then what does written notice mean? Yeah, maybe we could do something in the script too.
Yeah, and also I think it would be helpful just to show like there's way more of these corrections than there are written notices. At least in the data that you showed us, it was a
Right.
very different number. I think people have a perception that we can be very punitive as a board, and I think it would be really helpful for them to say, hey, we're just showing you, we're teaching you, we're giving you the opportunity to improve without it being a mark on your record. I think that would be a good educational point for members of the pharmacy community.
Thank you.
Hi, Chair Sharpa. I just wanted to add something really quick. So I was gonna say what Nicole was commenting, basically, I wanted to add that to the public discussion. So Nicole read my mind, or I read Nicole's mind, about the breaking down the, what it means, right? So after the inspection, I think regulated public would love to understand and know more of what they all mean, right? So everybody knows that after being inspected, they will get the inspection report. And Anne and Julie, please stop me if I'm incorrect, but so everybody would get the inspection report, but then, depending on the situation, that could be the end of the road. But then some of them who may have been found to be doing something wrong would get a order of correction or a inspection notice of violation, right? So it's either order of correction or the notice of violation. And then from there, I think what we could do better is to kind of educate on what happens after as well. What, do they get a citation? Do they get a letter of admonishment? I know those things won't happen right away. And I know that some of the licensees wait very anxiously and eagerly, not eagerly, but anxiously, of what is the outcome and how do they get determined. And every case, I know you can't answer this because it's really every case is, different. Every case has its own road that is not always same road, but it would be good to provide some general feedback of what they can expect if they are inspected and if they are receiving something like that order of correction or notice of violation. And then from there, what is the possible outcomes like? Because I think right now it's citation, obviously close, no further action is most common, but then education, letter of admonishment, citation, then going up to possible AG level, it's just explaining that, that spectrum of everything, it just helps people understand. So it takes the anxiety away from people. So that's one thing I wanted to add. The second thing, though, is amazing job. When we made this strategic plan in 2021, I just, I was one of those person like, oh, I don't know if this is going to happen, but you guys made it happen. So it took 4 years, but great job. Amazing work. I really appreciate it. And hopefully we'll keep it up, the amazing work. And so we'll be able to hopefully continue on this path of being able to inspect pharmacies every 4 years. Great work.
Thank you, Sung.
Hello, Julie. Thank you so much for the presentation. Yeah, thank you to everybody, all the inspectors. That is a Herculean effort. And it was great to see that final just statement that there'd been an inspection for the 4 years, which had been the goal for a long time and seemed difficult, especially in the pandemic years, right, of trying to do that. But I think that's really great. And of course, ultimately for patient safety. And then I do appreciate Nicole's comment and also with Song. And I think I would add that I think for clarity, perhaps even, the distinction to even be put onto the inspection report where there's You know, I mean, I'm familiar because I'm familiar with our, you know, like I'm practicing compounding pharmacist, so I'm familiar with the, you know, sterile compounding inspections and the you know, the inspection report. And I think it just would be helpful maybe that there was a reference box that just said, you know, what each, you know, each potential like what do discussion items really mean? And then you just kind of go, you know, kind of by each step as it gets towards a violation. And how that relates, because as a standalone, maybe not always clear. Certainly, the sum total is there's work to do, but I think sometimes the like what's the heavier meaning here for everybody to try to understand. So I think that could also be another place that it could be very helpful right on the document itself. So, but again, thank you to everybody for the tremendous work of inspections.
Thank you.
Hey, thank you,
Sorry,
everyone.
I had one more comment. I'm so sorry. I just wanted to compliment the inspectors. I've had we had an inspection at my pharmacy last year, and my PIC came out of it like enjoying it, kind of like they felt like it was a really good educational experience. They felt like the inspector was very helpful. I also love to use the Ask an Inspector feature. I always disclose I'm on the board because I don't want to freak them out, but I'm just like, I just love the feature and use it fairly regularly. So I've come across a lot of inspectors and they're super helpful. And I always enjoy getting to talk to them. So just wanted to pass that compliment on.
Thank you. I'll let them know. Thank you.
Great, thank you, everyone. I think just to summarize some of the discussion that we said here, just to remind you, we do have an annual presentation on the disciplinary process, but not everyone is listening to our board meetings. I mean, we find them fascinating, but not everyone is here with us. Maybe that could be summarized in a little short script article. And then if it's possible, Julie, I like what Renee said, is a like little one-page handout that could be handed out to people that defines the different terms. And that would be something that would be helpful. I know that we do that as people go through the disciplinary process. They get lots of educational materials, but maybe something upfront and maybe even just the script article handed to them would be helpful. Those are things that I think you could take back and discuss perhaps in public education. I think we're ready for public comment. I'd like to remind everyone that public comment is not a question and answer session, rather an opportunity to provide comments on the presentation. Julie, I can't see you anymore, but you are under no obligation to answer questions. In addition, as a reminder to commenters, please refrain from making comments on specific individual inspections or investigations to avoid any potential ex parte communication. We will begin with public comment in Sacramento. I don't see any. So moderator, we're ready for public comment from individuals via WebEx. And
Thank you.
Hey, Julie, so that we can hear her response if she desires.
Maria? Yeah, my mic is on.
We can't see you though anymore.
Okay. I
That's not you. That's the room. But that's
no,
okay.
it's
Go
the
ahead.
table.
Go ahead, Anne, moderator.
Thank
There I
you.
am.
And there's Julie. So if anyone would like to make a comment about the presentation or the issue, you may look for the hand icon and click that. And our calling users may press *3 to raise their hand. Each speaker will have 3 minutes with a 10-second warning. Are there any comments on the presentation?
We don't have anybody in Sacramento.
That's right. Correct. And I do not see any raised hands in WebEx. Shall I close that public comment feature?
Yes, thank you.
You're welcome.
Members, do you have any additional comments before we move on to the next agenda item? Seeing none, Julie, thank you again for the tremendous work, and please relay to the inspectors that we do truly appreciate the hard work to reach this goal of every 4 years and the positive comments that we received regarding communication with licensees. Thank you.
Thank you.
Moving on to agenda item 5, annual presentation on board citation program. Members, consistent with the strategic objective 2.2, on an annual basis, the committee receives the presentation on the citation and fine program that includes information on common violations. Generally, the information shared during the annual presentation is also included in the board's newsletter, providing education to licensees about the most common violations for which citations are issued. Ann Sodergren, our executive officer, will be making that presentation. Ann, the floor is yours.
Good morning. Thank you for the opportunity. As I do start my presentation today, I would just like to remind everyone that the board has a variety of different tools that it can use to resolve an investigation. And as Julie was talking about, there's a spectrum, right? So it could just be resolved with no further action through education and resolution of, corrections that were identified. We have letters of admonishment, we have citations, and then we have the formal discipline. So today I'm just going to be talking primarily about the citation and fine process, as well as the annual information that we provide on what we're noticing in terms of trends. So if we could go to that next slide, please. This is just the beginning of the very high level complaint and citation process. So it is split into 2 slides, but you can kind of see that it always is going to start with an investigation. We're not issuing a citation until we have evaluated the totality of the circumstances involved in an investigation. And then we have determined that there are violations of the law that have occurred and that the egregiousness of it, we believe, can be resolved through the issuance of a citation with or without a fine. If you could go to the next slide, please. So once that determination has been made, you'll notice that there's this slide shows, that we're the spectrum, right? Where we can close a case with no additional action. The other end of that spectrum is discipline. And then we have the citation and fine program that kind of resides in the middle. Once the board does issue a cite and fine, it's important to note that there are definitely appeal processes involved. Individuals can appeal to either an office conference and or refer the matter to the Office of the Attorney General, who will then represent the board in the citation matter. So if we can go to the next slide, please. So there's a variety of provisions of the law that really guide the board's citation and fine program. So the meeting materials include most of the relevant laws, and they're also detailed on the slide, so I'm not going to spend a lot of time, but we'll just point out the majority of the citations that are issued are pursuant to 4314 of the law. Next slide, please. So we have fine authority in, again, a variety of different sections of the law, both in the General Business and Professions Code, as well as in the board's specific pharmacy law. And then those provisions then determine the fine authority amounts for which the board can issue a citation. So as the slide indicates, Business and Professions Code 4067, which is a violation where you are dispensing a prescription pursuant to internet drug sales where there has been no appropriate underlying medical examination, we can issue a fine of up to $25,000 per prescription. In other cases, such as in Business and Professions Code 125.9, the board's maximum fine authority is $5,000 per investigation. Now, the law establishes the maximum amount, but I don't want people to think that we automatically default to that maximum amount, and we'll talk about that later on in the presentation. So if we can go to the next slide, please. As we briefly discussed during the public comment for items not on the agenda, there is no ex parte communication between the board and staff when we are working through an investigation and issuing a citation and fine. So the fines and citations are actually issued under the executive officer's authority. So the board then conveys its policy and what its expectations are with respect to issuing fines and the components that should be considered when assessing the administrative fine. So this is detailed out in the law. And then the slide just kind of details out what those factors are that we consider at the staff level when we are determining whether or not or what the fine should be. So if we can go to the next slide. We're now going to kind of dive into the data a little bit. So this slide shows comparisons data for a 5-year period. You will note that the number of citations issued is trending down. this shows not only for the citations issued, but then within those subcategories of citations being issued without a fine and those being issued with a fine. All of them are trending down. Fines assessed is going up, but that is in part because of some of those higher fine authorities that are relatively new in terms of the board. We do think that a lot of the decline in the overall citations can be attributed to a couple of different things. One is the board really focusing on education regarding compounding changes, especially in light of the changes with USP, as well as really working on trying to educate a little bit more about the new CE requirements and the existing CE requirements, and focusing on achieving compliance through education and an opportunity to correct. Next slide, please. So when we look at this is the overall time it takes from the time a complaint is issued until the issuance of a citation, you will note that the time frame is higher than it has been the last couple of years. Again, we would attribute this additional time period both to staff vacancies and transitions in leadership at the board, as well as the fact that we have improved upon our internal norming, which all takes a bit of time to ensure that when we are issuing a citation, when we are determining that a citation is appropriate and the fine, we are being consistent where we can. Want to highlight that no two investigations are exactly the same, no license histories are exactly the same, but we do strive to be to normalize the process as much as possible where the facts allow. So we're also this year providing, thank you. We're also providing citations by the different license types. And so you'll notice again, you can see that the trending down exists for most of the licensing programs. You will notice that non-resident pharmacies, there has been an increase in the number of citations issued. Pharmacy technicians are remaining pretty consistent, a slight increase. And really for pharmacy technicians, that's generally when we're issuing a citation related to some sort of criminal conviction kinds of things, where generally not something that is resolved through some kind of education or correction. Next slide, please. So now we're going to drill down a little bit more based on the different authorities. And so like I indicated at the beginning, the vast majority of the citations that we issue are under the board's authority in 4314. And again, this is where we are capped at a fine of $5,000 per citation. So you'll see the trending down as was on that first slide. So I'm going to skip to the next slide. This is citation and fine authority. Sorry, thank you. Issued specific for chain pharmacies. And so the data on the slide reflects the citations issued under the higher fine authority, consistent with the provisions designated on the slide, Business and Professions Code 4317.5A and B. So you will note that there's been a decrease from the last 2 years in the number of citations that were issued under this authority and the fines assessed. A significant number of the citations that were issued in the prior fiscal years do remain open because appeals are pending. Next slide. So when we look at that, I want to just kind of break down a little bit more. I talked about the fact that the statute will establish the maximum fine authority, but the board generally does not go to that highest amount, right? And we are looking at the board's direction through the regulation and those factors to consider. So you'll notice that the vast majority of the citations that are issued under this higher fine authority actually reside within the $1 to $10,000 mark, and then the $10,000 to $15,000. Very few of the citations that are issued under this authority exceed those fine amounts. If we could go to the next slide. So now as we start looking at the trends with the top types of violations, we have it again similar to the prior inspection. We do have it broken down by chain and non-chain pharmacies, and the hope that that information is a little more helpful to specific licensing populations as they're trying to determine where there may be opportunities for some improvement or those trends. I am just going to highlight as I go through some of these, you'll notice that the number of citations were pretty small. So we did put down a couple of the top violations, but given that the population is the number of citations issued in the area, we just want to give a word of caution that, given the sample size is small, I guess heed that as you're looking at the data. I don't know how else to say it. So next slide, please. So these are the top violations that result in a citation to a non-resident pharmacy. We do see quite a few delays in therapy, as well as some unprofessional conduct. Next slide. This is the data for the top violations for non-resident wholesalers. Go to the next slide. This is for pharmacists. So unprofessional conduct can encompass a lot of things. I also want to highlight the misuse of education, which is on the top violations. This is generally where a pharmacist has missed an opportunity at patient care. I don't know how else to say it, where at the staff level, we have determined that had they exercised appropriate education, the violation would not have occurred. Next slide. As I mentioned earlier, thank you. Pharmacy technicians generally are related to criminal convictions and arrest. And so those are really the top three that are there. We do find that sometimes pharmacy technicians work outside of their scope. Generally, when we find this, it's where a pharmacy technician is doing things while perhaps a pharmacist is on break. So that's an example of the bottom one. Next slide. So hospitals, again, these are some of the top violations, but just a reminder that we only issued 9 citations to hospitals during this reporting period. So these are some of the top violations that resulted in those kinds. Next slide. So now let's look again at the higher fine authority. And again, this really is demonstrating that the data reveals or supports the fact that the board is not going to those higher fines. So 4317.5A, under this authority, the board can issue a fine of up to $100,000 where there are repeated violations from pharmacies operating under common control and ownership. And that's like a simplified version of the law. Anyone that's interested in seeing the full law should look at the actual Business and Professions Code section. And then the next slide. Thank you. The provisions under 4317.5 are really different fine authority for the board. And in this instance, the board has the authority to issue a fine of up to $150,000. And that is where the board can demonstrate that it's as a result of the policies of the pharmacies under common ownership. But again, the fine authority is up to $150,000. And you can see that we did not go to the full amount for the citations that were issued in this past year. The highest fine was for $50,000, and that was related to quotas. Next slide, please. As the board and the committee remains focused on duty to consult, Julie talked about it, I'll be talking about it as well. This shows the data for the number of citations that were issued. Again, you'll notice this is under the Business and Professions Code 4314. And this talks about the number of violations that we had for failure to provide patient consultation and the average fine amounts for both pharmacies and pharmacists in this area. And the next slide, please. So this is where the board has issued fines for failure to provide patient consultation under its authority related to the community chain pharmacies. So generally, again, under the law, there's a requirement, a threshold where at least 3 violations have occurred before the board can be issuing these higher fines, and it has to be within a 5-year period. And again, I'm oversimplifying the law, would recommend that people read it. But this then shows that we've issued 10 such violations in this past fiscal year, and the average fine amount, again, well below the fine authority that the board has, the ultimate fine authority. So now let's transition over to orders of abatement. So under the law, the board has the authority to, as it issues its fines or citations, to issue orders of abatement, where essentially we are ordering that something occur as a condition to resolve the citation. So we can issue citations with or without the orders of abatement. The board gave direction to really begin using the order of abatements more routinely in 2018. So we continue to really use this as an opportunity to really try to facilitate compliance through many times additional education or requiring specific documentation. So if we can go to the next slide. these are some of the types of continuing education courses that we may require to resolve something. So if we're seeing that, you know, maybe someone was missing out on some opportunity, but it was not rampant, but we felt like based on the underlying violations, this person may benefit from the board's free prescription drug abuse prevention course, right? It's a 6-hour CE that crosses over a number of areas. We may issue a citation along with an order of abatement for an individual to complete that course. We also have the authority to require an individual to complete the ethics course as a portion of the abatement, and then additional types of trainings that are called out on this slide. If we can go to the next slide, please. Other types of abatements that go maybe beyond education, we may determine that the policies and procedures were just not adequate. And so we are going to request that they either update their policies and procedures and train it, and train staff, or they had policies and procedures, but staff were not aware of them. So we're maybe going to ask that as part of the abatement, they provide documentation confirming that that training has occurred. Next slide. So here are some examples of violations that do lend themselves to abatements. And so, you know, we talk about a spectrum on a pharmacy being clean, right? So there are times when we are going to result in the issuance of a citation. And as part of that abatement, we're going to say you need to provide us with photos that the issues have been resolved. And again, it's a spectrum, as Julie talked about, that spectrum. You know, a single dusty shelf is much different than an exceptionally dusty pharmacy with clutter, to rodents and everything. Right. So with that spectrum, where we determine that a citation is appropriate, but we need to ensure that that underlying issue has been resolved, we may assess an order of abatement as part of it and then request that evidence be provided. So next slide. We did order 53 orders of abatement as part of our citation process, and then abatement satisfied is 58. The reason that those numbers don't match is there is carryover from prior years. The orders of abatements include the time frame within which someone must provide the documentation to demonstrate compliance with that order of abatement. So you do see carryover from year to year. Next slide, please. So now let's talk about due process and the appeal rights. So as I mentioned earlier, individuals have a couple of different options. They can contest the citation to an office conference and or to an appeal through the Office of the Attorney General. So this slide indicates the number of citations that were considered during office conferences today, and then the outcomes of those. You will note that people participating in office conferences really does result in changes to citations. And I'm highlighting that because it is an appeal right that people have. And we would strongly encourage people that believe that they, you know, that there is additional context to the information that they can provide. It is absolutely considered through that office conference process. And as you note, results in changes many times, including, you know, dismissals, reductions from a citation to a letter of admonishment, or some sort of modification. Next slide. As I mentioned, the formal appeal process is run through the Office of the Attorney General in compliance with the Administrative Procedures Act. You can see that the total number of cases that were referred for appeal is 121. We have 131 appeals that are pending. And that again is because appeals generally take a long time to do once they are referred over to the Attorney General's office and cases are set for hearing and those kinds of things. So you'll note that we have 95 citations that were issued under the higher fine authority that are currently pending with appeals. Next slide, please. So when we talk about overall outcomes, these are the citation and fine numbers that were issued under 4314. Again, this is the general cite and fine authority where the board has the ability to issue a citation for up to $5,000 for the investigation. This shows the number of citations that were closed, the office conferences held, and then the appeals to the Attorney General's office. Next slide, please. This is the same kind of data for those that were issued under the higher fine authority. And with that, thank you for the opportunity to present, and I turn it back to Chairperson Serpa. Thank you.
Thank you, Anne, for the excellent presentation. And I am very pleased to see the breakdown by license category. I think that information is very helpful. I do have one question for you before I turn it over to members. And one of the slides talks about citations for unlicensed activity. Can you remark a little bit about why, well, you might not know why that's changed this last fiscal year, but what kind of activity falls into unlicensed activity? What qualifies in that group?
Sorry,
Okay.
citations for unlicensed activity can run a gamut.
Mhm.
A lot of times we see unlicensed activity where entities are shipping products in to either patients, so that's an unlicensed pharmacy, or they're shipping products into other locations, physicians' offices, types of areas where they require a license and have not achieved one. So we do have the authority to issue. We do have the authority to issue higher fines in this area. We can do it per occurrence. Well as we have the authority to issue cease and desist. I will just indicate that sometimes the cease and desist, it's an important tool. What we do find sometimes is we issue the cease and desist, and then it's an internet, it's an internet website, and then they just kind of, it appears that they reinvent themselves under a new website or web operator, if that makes sense.
Thank you. Members, do you have any questions or comments for Anne on her excellent presentation? I know you do. No one wants to go first.
I'll go just to say thank you so much. Lots of data. I think what I appreciate seeing is the increased effort in education during these different various types of incidences, from inspections or whatever they are, but that just seeing the decrease in some of the negative outcomes, due to, like what you mentioned about the, internal norming. And I think that process is working really well. So thank you for that. And just thank you for this whole summary. Super helpful to review.
I know Sun likes to go last. So Nicole, do you have any comments?
I agree with what Renee said. I was really excited to see that the number of issues is going down after all, trending down. And I know I'm biased because I'm a board member, but I definitely feel like I can see the education going up and the stuff coming out. Staff will see it in their emails and we'll be like, oh, I saw this, and like ask questions, and it starts discussion, and it's been really positive. So thank you.
Thank you.
Thanks, Chair Serpa. Thanks, Anne, as always. Just one clarification I'm hoping you can make for us, Anne, is the average days to complete. That is when the citation is issued to the point where either it is closed, as in they paid, or they accepted the citation, or that it's, whatever the outcome, right? That's the day, because it's like 406 days. So that's a lot. And I just want to make sure that everybody knows it's not from the investigation to being issued. It's from the issue date to actually being finalized.
So the data on slide, I think it might be the one on slide 8, Song, where it's average time. It's from the complaint receipt to the citation being issued. So it's from the time that we open the investigation, through the investigation process, through that norming and review process, to the issuance of the citation. Hopefully that clarified. I apologize.
That's very helpful. Okay, thank you. Because it just looks long, but there's a lot that happens in between. So I want people to be aware of that. Thank you, guys. Thanks, Anne, always. I have nothing further to add to as always, amazing Anne Sodergren. So thank you, and for all you guys do, and thanks to you and Julie and Cheryl and Janice now, all of you. I really appreciate you all.
Great. I think that means that we're ready for public comment. As a reminder, public comment is not a question and answer session, but rather an opportunity to provide comments on the presentation. As such, Anne, you're under no obligation to answer any of the questions. In addition, as a reminder to commenters, please refrain from making comments on specific individual citations or investigations to avoid any potential ex parte communications. I don't see anyone in Sacramento, so moderator Ann, we're ready for public comment via WebEx.
Thank you. This is the moderator. If anyone would like to make a comment on the presentation, you may look for the hand icon, typically at the bottom of your WebEx screen, or if you're on a mobile device, that may be behind the 3-dot other options. And our calling users can press *3 to raise their hand. Each speaker will have 3 minutes with a 10-second warning. Are there any comments on the presentation? I do not see any requests for comment. Shall I close that feature?
Yes, thank you.
You're welcome.
Great. Thank you, Anne, again for the excellent presentation. We truly appreciate the work that the staff and inspectors have done, and under your leadership, it really is great presentation. I believe, members, if you're okay, we can make one more presentation before we take our break, and that would be a good transition. So are you okay with going through one more presentation? Agenda item 6, presentation on quality assurance reports received pursuant to California Code of Regulations, Title 16, Section 1711F, related to the use of automated drug delivery systems. Members, BPC Section 4427.8 required the board on or before January 1st, 2025 to report to the legislature on the regulation of automated drug delivery systems, or ADDS units, as a part of the sunset evaluation process. This report was submitted to the legislature in January of 2025. In addition, 16 CCR Section 1711F establishes an ongoing reporting requirement for quality assurance records related to the use of an ADDS as specified in that section. You may recall that during our July 2023 and July 2024 committee meetings, members received presentations on the findings of QA reports received. The reports revealed what appeared to be a lack of compliance with reporting requirements. Staff continues to educate licensees on the reporting requirements. Thank you to everyone for your reports and to the staff for performing additional education about the mandatory requirements. I welcome Janice Dang, PharmD, she's Chief of Enforcement, to provide the presentation on the data received from these reports for fiscal year 24-25. Janice, I think you're there.
Good morning. Can you hear me?
Good morning, Janice. Yes, thank you. The floor is yours.
Okay, thank you very much. Good morning, everyone. Today, I will be providing an update on the board's Automated Drug Delivery System, or ADDS program, which will include the number of ADDS licensed this fiscal year, the type of ADDS licensed by the board, and provide a summary of the ADDS related medication errors reported that were submitted. Next slide, please. Okay, as a quick review, an ADDS is an automated drug delivery system, or a mechanical system that performs operations or activities other than compounding or administration relative to the storage, dispensing, or distribution of drugs. An ADDS also collects, controls, and maintains all transaction information to accurately track the movement of drugs into and out of the system for security, accuracy, and accountability. Next slide, please. An ADDS is classified as either an AUDS or an APDS. An AUDS is an automated unit dose system used to administer unit dose drugs to patients. Individuals authorized to administer drugs are provided access to the AUDS to remove a drug, whereas an APDS is an automated patient delivery system used to dispense prescribed drugs directly to patients that's been reviewed by a pharmacist. An APDS is required to have a telecommunication link that has a two-way audio and video. Next slide, please. Here are a few examples of an AUDS from left to right. The first example is a Pyxis. This is an AUDS that has multiple towers. These larger types of AUDS are often used at hospitals or at skilled nursing facilities to store large drug products that do not fit in the drawers of the smaller units. Some correctional facilities may also have one or two of these larger AUDS at their correctional clinics. The second example in the middle is the Omnicell. This is the most common size of AUDS often used in skilled nursing facilities to provide emergency doses or the first dose for a new prescription. Both examples, the Pyxis and the Omnicell, utilize individual packaged unit dose medication. The third example on the far right is the StatSafe. This AUDS is different from the Pyxis and the Omnicell. The StatSafe contains multiple bubble cards of medications. The nursing staff will usually remove a dose from the bubble card for an emergency dose or the first dose for a new prescription. Next slide, please. Okay, these two devices, the Alexa RX and the Talis Insight, are also considered an AUDS. These AUDS contain multiple canisters of drugs that will package a patient's medication in sealed pouches for a specific MedPass time. In other words, if a patient is taking 4 different medications in the morning, all 4 medications are packaged in one pouch. Next slide, please. These 3 examples are examples of an APDS, where they dispense the drugs directly to the patient. The first APDS is the Medavail. This APDS was located in a medical office. This device contained pre-filled vials of medications and has the capability to print and adhere the prescription label to the vial, which a pharmacist can review remotely through the use of cameras. The second APDS is the Parata that was located adjacent to the pharmacy. This is a locker type of APDS, which prescriptions filled by the pharmacy are placed into the APDS for patients to pick up. Patients can request their refills to be placed in the Parata for pickup or to pick up to avoid standing in long lines at the pharmacy window, or to pick up after the pharmacy is closed, but the front end of the store is open. The third APDS is the Script Center. This was located adjacent to the pharmacy, again for patient pickup. And this is also another locker type of APDS. All 3 devices have the 2-way audio and video capability for patient consultation as required by law. Next slide, please. Okay, the board currently has 3 license categories. Category 1 are the ADD. These are the ADDS licensed pursuant to Business and Professions Code 4427.3 and 4427.65. The majority of the board's licensed ADDS falls in this category. These are the ADDS located at skilled nursing facilities, medical offices, correctional facilities, emergency room, adjacent to pharmacies, in your psychiatric health facilities, and other locations licensed by the state with statutory authority to provide pharmaceutical services. The licensed ADDS can either be an AUDS or an APDS. Category number 2 are the ADC. These are the ADDS operated by a pharmacy and are located at a covered entity, usually a clinic, pursuant to Business and Professions Code section 4119.11. The covered entities are clinics that have the capability to purchase 340B due to their contracts to purchase the drugs, and the APDS is used to dispense prescription medications, again, directly to the patient. And then category 3 are the ADE. These are the ADDS operated by an emergency medical service that has either a pharmacy or wholesale license. These ADDS are AUDSs located at designated fire stations throughout a county used to restock paramedic trucks. Next slide, please. Okay, for this fiscal year, as of April 30, 2025, the board has licensed 1,169 licensed ADDS. Again, this is the category that most ADDS are licensed under. The board received 163 applications, of which 154 licenses were issued. Prior to licensure, a pre-license inspection is required prior to issuing the new ADDS license. Next slide, please. The board currently has 3 licensed ADC. These are the clinics that are considered covered entities. The board received 4 applications, of which 2 were issued. Next slide, please. Currently, there is only one ADE. This is the ADS or the ADDS associated with an emergency medical service. Between all 3 categories, the board currently has a total of 1,173 licensed ADDS. Next slide, please. Regarding medication errors related to the use of an ADDS, pursuant to California Code of Regulations 1711F, facilities operating a licensed ADDS are required to submit their medication errors related to an ADDS within 30 days of completion of a quality assurance review. Facilities operating an unlicensed ADDS are required to report their quality assurance review to the board annually at the time of their facility license renewal. This fiscal year, there were less pharmacies reporting their ADDS related to medication errors. A total of 47 facilities reported their medication errors with a total of 799 medication errors. Next slide, please. The top 3 locations based on what was submitted to the board where ADDS related medication errors were reported included the correctional facilities, which with 535 medication errors, hospital pharmacies reporting 177 medication errors, and 68 medication errors by pharmacies servicing skilled nursing facilities. Next slide, please. As for the type of errors based on the location of the ADDS, at the correctional facilities, the 535 medication errors reported included or resulted due to administration of the wrong drug, strength, quantity, or patient, and unauthorized dispensing. Unauthorized dispensing occurs when nursing staff uses the override function to the ADDS to gain access to the ADS to remove a drug prior to a pharmacist reviewing the order. Many of these errors at the correctional facilities were contributed to the movement of inmates to and from different prisons or different yards within the prison. For the pharmacist to determine the cause of the error, we were informed that this was a very labor-intensive process since the pharmacy's computer system was not linked to the prison's medication administration system and therefore required manual reconciliation. For hospital pharmacies, they reported 177 medication errors related to the administration of the wrong drug, strength, quantity, or patient, and unauthorized dispensing. For pharmacies operating ADDS at skilled nursing facilities, there were 68 errors that were reported related to wrong drug, strength, quantity, or patient, and again, unauthorized dispensing and a packaging error. When we compared last year's reporting to this fiscal year, we based it on the percentage since the quantities were different. For correctional facilities, what we saw was a decrease in the number of wrong drugs dispensed. We saw a decrease in the dispensing to the wrong patient, and we saw an increase in the errors related to unauthorized dispensing. Whereas for skilled nursing facilities, we saw the dispensing of the wrong drug increase and also an increase in the dispensing of the wrong strain. However, we saw a decrease in errors related to unauthorized dispensing. As for hospitals, the percentage of medication errors increased for dispensing to the wrong patient And for unauthorized dispensing, we actually saw a decrease. And that decrease was pretty significant. It was from 39.2% to 2.99%. Next slide, please. The majority of the errors reported were related to the use of the AUDS used for administration. Comparing the data from last fiscal year, the percentage of medication error related to unauthorized dispensing decreased from 21% to 13.4%, and the number or other type of errors were pretty consistent. As for medication errors related to an APDS, which dispenses directly to the patient, there was one medication error reported related to the dispensing to the wrong patient, compared to 0 errors reported last fiscal year. This error was related to the APDS malfunctioning and allowing the wrong drawer to be released with another patient's medication. Thank you, and this is the end of my report.
Thank you, Dr. Dang, for the comprehensive presentation. Every year, I'm always fascinated with the changing numbers of reports. And it appears that we still have an issue with under-reporting QA records for ADDSs and confusion on the reporting requirements. This makes it difficult for us to evaluate the true nature of the errors because there are significant under-reporting. Over the next year, the board will continue with outreach and educational efforts. Before we go on to member comments, I'd like to really make it clear, because I, as a board member that represents acute care pharmacy and working with ADDSs in hospitals and acute care, I wanted to make it clear to the regulated public that 16 CCR section 1711D requires all medication errors discovered be subject to a quality assurance review. In addition, for such errors related to an ADDS, there are 2 separate reporting requirements in 1711F. And if you're not familiar with them, please look up 1711F. The first reporting requirement is for a licensed ADDS. QA records related to the use of a licensed ADDS must be submitted to the board within 30 days of completion of the QA review. The second required reporting is for any facility with unlicensed ADDSs. They must report a QA review to the board at the time of their annual renewal of facility license. This includes hospitals. I know there are a lot of hospitals listening. This includes hospitals that have large numbers of unlicensed ADDSs, and they are required to send a QA report of all ADDS medication errors annually to the board. So if you're listening, please go back and look and make sure that you have submitted your annual reports, because as you can tell by Janice's presentation, very few reports are coming from hospitals, and I know that's a challenge for us. Members, do you have any questions or comments for Dr. Dang?
I just have one add on to your comment, Chair Serpa, and Janice and Ann and Julie can please correct me, but I am understanding that also for a unlicensed ads used in a pharmacy just for purposes of counting and pouring, if there is a medication error that occurs with that device, it still needs to be reported to during the time of renewal. So I think that part of it is also not well understood among the regulated public. And I do believe we are implying that in our FAQ related to ads. We have it on our website, but maybe make it very clear that also those devices, they may not need to do self-assessment. They may not need to do a lot of other things. But I am under the impression that they need to submit the quality assurance review at the time of renewal for those devices that are being used for counting and pouring purposes at the regular community pharmacies as well. So Janice, hopefully that's correct, but if not, I am gonna never mind that, but that's my understanding.
So that is correct. I think there's a misunderstanding prior to 1711F going into effect in think it was July 1st, 2021, that reporting the QA related to the ADDS was generally voluntarily because it was, and when 1711 took effect, it included, regardless if you're licensed or not licensed, it's all unlicensed. And that would include pharmacies that are operating an ADDS used for technology to count, label, and fill the prescriptions.
So with that, I would ask, since those machines are not something you're going to miss when inspectors go in, so if any inspectors see those, I think we need to make a very conscientious effort to remind and educate regulated public that, you have this robot, you're gonna, remind them if there's any medication error, which I know a lot of them happens related to robot because, it was filled incorrectly, whatnot. So let's just make that a priority for our inspectors.
Thank you. Any other member comments? Okay.
This is Renee. I think just to add that, in terms of what's being described as medication error from 1711B, medication error does not include any variation that's corrected prior to furnishing, right? So it's something that actually reaches the patient.
Yes.
Right. So, yeah, I just think just to acknowledge that one, that there's not, I think, in a hospital setting, we're looking at a lot of near misses. We report for our, quality review, right? But they don't get to the patient, but we're looking at processes ahead of time. Anyway, I mean, it just, I think it can be fairly low. So
it is a good point that
Take it.
people need to review the 1711 so they understand the definitions. But it is quite concerning that over the last 3 years, we've received very few reports from hospitals. And so we have hundreds of hospitals that have licensed pharmacies. And so just wanted to bring it to their attention because a QA report could list, it has to be a QA report. So a missing QA report makes it look like you haven't reported. So I'm sure as inspections are going on, the inspectors are reminding people. So hopefully next year's report will have significant data so that we can actually evaluate where are the errors occurring. The numbers are so small now that I think we only have a small window of looking at what are the errors out there with the ADDSs. Members, any other questions?
I'm going to just naively believe and hope, not believe, but hope that all the hospitals are just doing amazing. So I just want to hope that, I think although I have visited many hospitals, thanks to all the, posts of welcoming us, there are hospitals out there that are just so amazing and top of the line, top of the notch, and they really do their best to ensure there's like 0.000 error. So I really appreciate it. I have one question for Janice. Chair-Sarpap, I'm sorry, about ADEs. I know that's not talked about a lot and we really kind of don't pay much attention, but I know this was talked about like in the 15, 16, 17, feels like ages ago. Do you have any clues to why that is not being used a lot by the regulated public?
So I was around in 15, 16, 17, and originally it was a specific large county that was concerned about taking their paramedic trucks out of commission because they had to go to the county pharmacy to restock their trucks. And so with the program, it allows them to keep the trucks closer to the fire station. Because it allows them to put the ADDS at designated fire stations so they can go there to get their trucks restocked. My understanding with a lot of the other emergency medical services is that their counties are not as large as other counties. The majority of them were okay with their their system. The other issue was related to, and I think this was as part of the board meeting, where all the medications that were used or acquired for the paramedic trucks were done under a specific medical director's license. And this was given another means of where it wouldn't use the medical director's license to obtain controlled substances. Instead, these EMS will have, their own pharmacy license or their own wholesale license and purchase the controlled drugs under that, the pharmacy or the wholesaler's DEA number. So again, the smaller counties that were not as large felt comfortable with their medical directors felt comfortable with the existing system that they had, that they did not want to change.
Thank you, Janice.
One more point to consider before we go to public comment is there's been discussion, and I believe it would be helpful that staff consider developing a standardized template for reporting ADDS quality assurance reports to the board under section 1711F to aid, not only to aid in compliance, but in consistency of the data elements. As you note in the report that Janice just gave us, 25% of the reports received did not contain sufficient information to determine the type of medication error. That's a very large number. And I believe standardizing the QA reporting elements may be able to address this issue. Members, do you have any comments about the opportunity for standardized reporting? The silence means everyone agrees that the staff should look into that, or?
I think that we can definitely take a look at that, Chair Serpa, along with, our medication. Well, I think we need to just clarify, because QA is for all licensees. There's a mandatory medication error that is being turned on September for all outpatient pharmacy population who may or may not also be involved in the ads usage. So there's a lot of layers, and I think that it will be a little bit of an education for many involved. So I think that, yes, we should look at it, but with a lot of focus on really kind of diving down and making sure we're educating the regulated public in terms of what is the expectation.
Yes.
This is Renee. I think that might be helpful. I think we could take a look at that. I think I would keep it as strictly related to the regulation itself, and just really minimize the number of just optimize the questions to sort of minimize the questions, if that makes sense, right? I mean, there's a lot of questions that could be asked, but I think keeping it to the actual nuggets of pertinent information to make it a little easier to complete, not make it too long.
Yeah.
I would keep it at just exactly what is missing. Especially looking at what's missing that people didn't put. Did they miss something obvious like the strength or the drug or something, or is there just something that everybody's missing and that would be really needed? What is really needed, right, to assess? So that would just be my input for that. But I do think maybe something standardized so that not everybody is reinventing the wheel for submission.
That's a good point. I think that looking at it being streamlined, not only from the licensee's point of view, but also from the inspectors or the staff's point of view. Right now, I understand these reports are coming in narrative form. So it takes a lot, not only to write a narrative, but it also takes a lot to read the narrative to figure out what the data elements are. So something that's streamlined for both groups would be great. Nicole, anything to add, or we're going to go to public comment? Okay, Before we begin,
Sorry, Maria, can I just add, I do think that yeah, I mean, just sometimes there really needs to be some clarification. Sometimes a checkbox is maybe not the most accurate, but can be in a lot of cases. So especially with these types of situations. So anyway, I would agree it's hard to write it up and it's hard to read it. But again, sometimes a checkbox makes it maybe that's not able to be reported as accurate as you would want it to be.
okay, thank you. Well, let's move on to public comment. Similar to previous presentation, just as a reminder, public comment is not a question and answer session, but rather an opportunity to provide comments on the presentation. As such, Dr. Dang, you're under no obligation to answer any of the questions. I don't see anybody in Sacramento, so Moderator Ann, we're ready for public comment for people via WebEx.
Thank you. We already have 2 hands raised, but at this point, if you have a comment on the presentation or the discussion, you may look for the hand icon and click that to raise your hand. Our call-in users can press *3 to raise their hand. And let me go ahead and show the instruction slide 1 quick second. And thank you. And so we will take the people in order, and you have 3 minutes with a 10-second warning. We have a request from SA. SA, I've sent you a request to unmute.
Yes, good morning. Thank you so much, Dr. Dang, for a wonderful presentation. I couldn't agree more with Renee's comments in terms of everybody needs from the, and I'm a pharmacy director for an integrated system, hospital and health centers. And the main comment that I'm making is for the hospital setting. We are under the obligation since 2001, actually, to keep a very close tally of all medication errors under the laws of medication error reduction plan. So we have a very robust system. Unfortunately, this would be duplicating a lot of our processes, and the definition has been less than clear. So I couldn't agree with Renee more in terms of clarification is required. In addition, 1711B definition clearly excludes near misses, yet we had the lovely opportunity to speak with one of your inspectors, and she clarified that those are really needed and reportable. So it's like it added on to the layers of confusion. And the definition of dispensation is very different from the global understanding of the word dispensing, meaning whatever is situated in these automated dispensing cabinets, if there's any error, and if it's not reached a patient, it is still reportable. So those are near misses, but we consider for CDPH as near misses. Now board wants it reported. So it would be nice. I mean, I took shots of the presentation, lovely presentation that Janice just gave us, so we can explore the headings that she collected, so we can basically create some document for ourselves what you were referring to, Maria. And this is basically I want you to understand, please, that, we are under a lot of stress, under a lot of laws. Board of Pharmacy is one of the many entities that, regulates us. We are, we have obligations towards a lot of other entities. CDPH for years, for decades, has been the major entity that we've had, great obligations to concerning those 12 elements that everybody has to get. It's like those are all performance improvements, frankly, mini performance improvements. So this is, I need you to be sympathetic with all the hospital practitioners, that, and all the other obligations, and try to be more productive as a whole, as an entity, basically, to do what the right thing is, and basically, give us an opportunity to help you with your data collection, in the least crowding kind of a, position, if that makes sense. I'm happy to answer any question that you may have if I haven't been, vocal enough in certain area that I raised.
10 seconds.
I'm done.
Can I answer that question or make a comment?
Certainly, Dr. Dang, if you'd like to make a comment.
Okay, so if you review 4427.4 D like in dog, what that code section states is that drugs and devices dispensed from the ADDS shall be considered to have been dispensed by the pharmacy. So it's my understanding, if I recall correctly, there is an FAQ for the ADDS that discuss that depending on what the error is, if it's dispensed from the ADDS, that it should be reported to the board because the way the law was written. The FAQ also addresses what is a near miss as well. So I think that's where the inspectors may be coming from when they're telling you to, report them. And then also when we first started doing the tracking of the medication errors, at that time in 2019, it was generally voluntarily. So we were trying to encourage pharmacies as much as possible to report the errors so we could learn what are the issues related to the ADDSs. And then when 1711F was, went into effect, it required, all, whether licensed or unlicensed, to report the ADDSs. So I just kind of want to make that comment.
Thank you.
And we do have a comment request from Andre Peters. Andre, I'll send you a request to unmute your mic. You'll have 3 minutes with a 10-second warning.
Good morning. Can you hear me okay?
Yes.
Thank you. Thanks for the opportunity to comment. I'd maybe just add some comments here that could help allude to some of the confusion and by the way, I'm speaking on my capacity as Director of Regulatory Compliance and Medication Safety for Scripps Health. I'd like to allude to maybe some of the confusion with reporting here. And so the first one is, I think I'm continuing to notice a conflict between this requirement to report QA reports, because BPC 4125B also states that QA reports are peer review and therefore is protected. And so I think that maybe causes confusion that the peer review protected document must be shared with the board. Also, I think Member Barker pointed out some confusion around what is a medication error, which is specified in the QA regulation as an error that reaches a patient. And yet we have that already written in the regulation, and then there's also the expectation that anything that might potentially reach a patient also be reported. And so that was actually pointed out by some commenters during this rulemaking process on this topic. I'm also wondering if reporting would be more robust if it is being made anonymous, similar to the current process that is going to be starting sometime soon with med-error reporting with the ISMP. Naturally, I think there might be a reluctance from licensees to report errors if they feel that if every report is going to lead to discipline. So just wanted to kind of highlight some of the concerns that I've heard out there that could maybe help the overall improvement with perhaps the board providing clarity and perhaps maybe addressing some of the concerns and some suggestions. Thank you very much for the opportunity to comment on this.
Thank you, Dr. Peters. I think one thing that I'd like to draw to everyone's attention is mentioned about the FAQs, but additionally, when this regulation was written, there was significant discussion about some of the questions that you mentioned. And so that's, if I remember correctly, that's the main reason why the unlicensed ADDSs reporting was limited to an annual report, so that you don't have to send in every single incident within 30 days, because there would be potentially more, since acute care facilities often have 50 or 100 plus ADDSs, that it would be summarized in an annual report. And I don't think that would be containing patient protected data. But I'm certain that you could we're going to talk about ask the inspector in our next presentation, but I think that those are really good comments that Dr. Peters made. And I think that if we need to provide clarity to people, I think that would be helpful. Dr. Deng, do you have anything else to add?
No, I don't.
Okay, thank you. Next Moderator Ann.
Correct. There are no further requests for comment. So shall I close the public comment feature?
Please do. Thank you.
You're welcome.
Members, do you have any further comments or questions? It sounds like that we do have a little bit of confusion out there with the licensees. Okay, I think we do have an opportunity. Oh, so go ahead.
Sorry, Maria. Yeah, I was just trying to search through the FAQs. Do you know which number that is of the FAQs, just for discussion?
I don't have the FAQs in front of me, but I
Okay.
know that there is a significant discussion in the FAQs regarding the timeline of how the ADDS works. And certainly we could review the FAQs, and maybe that's where we should go, is review the FAQs that we have to provide more clarity in line with what kind of data that we're getting. And maybe at that point, put some suggested data elements. I think that's something we could direct the staff to do, is to review the FAQs to help provide more clarity on the reporting requirements. What do you all think?
Sounds good to me.
Okay.
Yeah, I'm looking at FAQ 7, and then maybe we can discuss that at a later time too, because I feel like it's not quite in line with 1711B.
Okay.
But I'm also reading it hastily
Okay.
on the spot here, so I just not thorough. But the definition of medication error, I feel like it personally, and I don't think it matches. But
that's something that we have discussed in past meetings, and it is quite a puzzle there. And Dr. Deng kind of referred to it a little bit, but I think we could probably have a more robust discussion by reviewing the FAQs and dive deep into that difference and why it's interpreted that way legally. So I appreciate that. So let's do that going forward, is let's review the ADDS FAQs with an emphasis on reporting requirements, and maybe add a few more questions to clarify. Okay. Thank you, Dr. Deng, for your presentation. As always, it causes us to think more closely about how we can improve our processes to improve patient safety. So thank you very much. I think that this is a good time to take a break. It's 10:56. I know we have to take a 15-minute break. It is okay if we round up and just be back at 11:15. Give you a few more minutes.
Sounds good.
Okay, 11:15. Thank you all. I think everyone is back. Let me take a roll call vote, or vote attendance, sorry. Renee Barker.
Present.
Sung Ho.
Present.
Nicole Thibault.
Present.
And I'm present, so we can continue on. Thank you all. Agenda item 7, discussion and consideration of updates to frequently asked questions related to the board's Ask an Inspector program. Members, as a part of its licensee education efforts, the board offers a service whereby board inspectors and staff are available to respond to verbal and written inquiries from licensees. The board has compiled a list of FAQs that it has received through this program. The board's Ask an Inspector FAQ were originally drafted in 2021. Included in attachment 2 are updated FAQs being recommended by staff. FAQs 1 through 13 are existing FAQs that have been updated, and questions 14 through 17 are new FAQs that are being proposed to be added. I'd like to highlight a few changes for the committee. Question number 1 provides clarification on pharmacists performing final verification if the medication is filled by a pharmacy technician or intern. A reference to BPC 4115.5B3 was added to the reference provisions pertaining to verification of prescriptions prepared by technician trainees that was not previously included in the FAQ. Question 3 addresses technician ratios in community pharmacy. The updated response addresses expanded duties of pharmacy technicians under AB 1286, including ratio requirements. Question 9 asked, where is the law that establishes the requirement for a pharmacist to exercise corresponding responsibility? The response was updated to add a reference to subdivision B of section 1761, which provides, quote, even after conferring with the prescriber, a pharmacist shall not compound or dispense a controlled substance prescription where the pharmacist knows or has objective reason to know that said prescription was not issued for a legitimate medical purpose, unquote. This is a more complete answer to the question, as prior versions only referenced the relevant section of the Health and Safety Code. In addition, 5 new FAQs were added. Question 14 was added to clarify remote verification of a medication chart order. As noted in the response, there are 2 separate authorities that allow for remote verification of chart orders. 15 was added to address whether a QR code may be provided to the patient instead of a medication guide in a paper format. 16 was added to explain staffing requirements in a refill chain community pharmacy. 17 was added to address whether a retail pharmacy is required to keep physical prescriptions, or can the prescriptions be scanned and kept electronically. And finally, 18 addresses the identification required to be worn for techs and pharmacists. I had an opportunity to review the FAQs and believe that they are comprehensive and appropriate. Members, do you have any comments or feedback on these FAQs? And if possible, I would recommend a motion to approve if you believe such action is appropriate. Members?
Thank you, Chair Serpa. I have a few. Oh, go ahead, Nicole. You're gonna go.
Yeah, I can go. Thank you. And I have some construction going on, so I apologize if you guys hear background noise. I just wanted to say I thought the additions were really helpful. I actually learned a few things reading them. I particularly liked in question 18 where we provided the specific examples of how the name could be. This question comes up a lot, that people don't know exactly how to do that. So I'd love to see, when possible, more things where we use a specific example. One thing, a kind of misconception that I hear a lot about Ask an Inspector is that people are afraid if they ask a question, it's going to like somehow trigger the board to like come look at them or investigate or do something like that. So I should have mentioned this earlier, but I would love if there could be some kind of like a disclaimer or some kind of a statement that like using this is not like trigger something, because I see people hesitant to do it because they think, but like I said earlier, it's like one of my absolute favorite things. I use it like every time a question comes up. So I think it would be helpful if we could clarify that somewhere. But I really like the additions. And I'll let everybody else go but I would make the motion if everyone else feels the same.
Sorry for the lag. I don't know why my getting to the unmute button is just a little longer for some reason today. Yes, absolutely. I would support a motion. I do have some suggestions for us to update and add. Pending legal review, probably post-meeting, to confirm what I'm going to blab on is going to be approvable by legal to add on.
Okay. So we may be seeing another question in the future meeting.
or just some clarification. So I'm gonna start. Do you want me to go, Maria?
Sure, go ahead.
Okay. So on the question one, I love the addition, but can we also add CCR 1712, which basically says that any requirement in this division for a pharmacist to initial or sign a prescription record or prescription label can be satisfied by recording the identity of a reviewing pharmacist in a computer system by a secure means. The computer used to record the reviewing pharmacist's identity shall not permit such a record to be altered after it is made. The record of the reviewing pharmacist's identity made in a computer system pursuant to subdivision A of this section shall be immediately retrievable in the pharmacy. So I don't want that question one's answer number two to make it seem like that a pharmacist in this day and age in the year 2025 must hand signal, because that has not been the case forever. And I don't want anyone reading that, because pharmacy law must be accounted in totality. And this is where it gets so confusing, right? Because it's the whole book, not just a section. And I struggle at myself all the time, as I'm sure everybody listening, or all the ones, all of us. So I would like to make sure that we include that it can be electronic signature essentially is sufficient, and it does not need to be the initialing the prescription label, because I think that it's always possible. So I have a few more, so if I can keep on going, and then we can talk about as in totality. Question number 6, I really do think that, again, I know that we are not allowed to give legal advice or interpretation of the law, but we could probably add a section in our BPC, not BPC, it's actually Health and Safety Code, that allows a pharmacy to fill the remaining portion of a Schedule II controlled substance that mirrors the DEA's regulation. This again is a very confusing, and a lot of people ask questions. It's the word refill, right? Yes, the word refill. You cannot refill a prescription, but we probably want to add a caveat that you can dispense the remaining portion of a prescription if it's not dispensed originally within a 30-day from the written date. So that probably could be added. I don't think that's adding a legal interpretation or I think that's just clarifying what the law says. So I'm hoping everybody's agreeable, and Corinne can let us add on that. Question 17, I do really appreciate that. But if I'm reading the answer, I'm not really clear if it is saying that it must be kept in its original form, because that's what I think what it's saying, but I'm not getting it. I get that we cannot give a legal interpretation, and we're just restating the law. But also keep in mind that we are attempting to change digitization, right? So if what we succeed through sunset, I believe the answer is going to change a little bit. So I just want to flag that for everybody, and let's keep that in mind. And lastly, question 18, I just want to make it very clear, because this is something that I myself struggled and a lot of organizations would struggle. So all those examples are acceptable, and that's cleared. So I had some conflicting conversation, I think, from what I had with our staff. So I just want to make sure that John D is acceptable, because that is and I'm sure if it's published by our FAQ here, then it's acceptable. But I've had some conflicting information given by some people, so I want to make sure that that's absolutely correct. And that's all I have.
Thank you.
Can I follow up on something from Sung? Thank you. You reminded me. I think your point about the C2s is super important and clarifying, because of the shortage on the ADHD drugs. Like, people are unsure if they can give the remainder, and that's just making the problem worse with patients not having good access to the drug. So I think that is a really important clarification. And I totally forgot the point I had wanted to make about question 18. Would love if there could be some guidance around when someone has a preferred name. And this can happen in a lot of ways, but I look specifically to our trans regulated public. I would really hate the idea that we were going to make someone who is trans use their dead name. That's extremely inappropriate. But sometimes people have to have their legal name on their board license, but they absolutely do not go by that name. They use their middle name, they do whatever, and that's what's commonly known. So that would be really helpful to clarify in there as well. How do you deal with a situation where maybe they're not going to use the matching legal name to their board license?
That's an excellent question. Renee, do you have something to say before I kind of summarize?
Yeah, just again, following on to question 18 and kind of from what Sung and Nicole both said. So, I mean, I think assuming that's okay, that they use their, like John D, that is actually a trend for worker safety to not have their last name identified. So that is the route that many are going. So I'm assuming that should be okay. And then also I would completely echo what Nicole is saying, because we do have quite a few staff who have just other, for lack of a better word, typical American names. And so they go by another name than maybe, a name that unfortunately people have trouble pronouncing or reading. So, and they're just known by that name and not their actual original name. So even though in the documentation in the department, that name is certainly known, but on their name tag, they prefer to have that because that's what they go by. So there's a translation somewhere of their name, but it's not specifically their license from their license status.
Okay, thank you. I think what I'm hearing is that we can have staff work with legal counsel to update questions number 1 and number 6 to provide that additional information. I did need to hear, I think, a little bit from Corinne or Julie regarding 18, because the examples were interpretations. They're not strictly in the law. So how do you respond to the concerns about using an alternative name for whatever reason?
Hi, this is Corinne. Yeah, I mean, I will speak to that to say that, I mean, we've quoted what the law says in the answer, and that is the only guidance that there is on it. There is no definition of what does it mean to have, your name. Is it preferred name? Is it first name? Is it first and last name? So, I mean, Jennifer's here as well. I mean, my recommendation would probably be, if you really want to get specific about it, to consider, adopting a regulation that interprets it more clearly. Otherwise, you do have the example here. So I think it's whatever you put on here is what you're saying the inspectors are going to accept. I don't know if Jennifer wants to comment on that anymore from a regulatory standpoint.
Just that I'm in agreement.
So it sounds like we have the choice of not putting any examples or being silent to other forms of the name, because you look at specifically Johnny is not the name of John Doe. That's his preferred name, I guess you could say, but it doesn't specifically answer the question. Sung, I saw your hand up. Did you have a better answer?
Oh, no, I just wanted to ask about, considering this is coming from the 680, the BPC 680, and we have 29 Healing Arts Board, I'm just, can we see what other boards have done? And maybe they have some foresight into what we're discussing, because I would imagine someone has or may have already looked into this. But I will strongly advocate that we do need to leave example on here as displayed here, because this will just clarify a lot of confusion out there. I really would like for us to keep this example if it is appropriate legally, because there has been so much chatter about this, believe it or not. I have been asked a question about this myself and have, so it would be really helpful, and maybe we just, in the end, ultimately, my point that I would like to make it very firmly is that, yes, I think a licensee needs to display a name so that regulated public and also public at large can, if needed, to get the person's name so they can ask us to maybe intervene if necessary. However, I feel very strongly that a requirement to display full name is a little bit too far, and that I think that we do really need to be mindful of employee safety and what are the possible unintended consequences. And I feel very strongly about it. And I think we just need to be mindful of that, because, you know, I'm not going off of this of anecdotal stories, but I think it's just been so many instances that occurred and have been a real world scenarios where I think an employee or a licensee has been harassed, embarrassed. And, I do think that we just have to absolutely be mindful of those possibilities, and just have to be really aware. And so hopefully we do not prioritize these things as an important issue as inspectors look for these things.
Mhm. Yeah, I think this is a very complex issue, and I would suggest that we ask staff to evaluate preferred name, alternative names, or nicknames as further review, and then we can talk about it at a future meeting. But going forward, to recommend that we recommend to the board that they approve it as written, and we could do some more evaluation on the non-legal opportunities, because it sounds like legally we can't really speak to that, but I think we should have some discussion and perhaps have to have a regulatory change if it's needed. With those.
Sorry to interrupt.
Who's that?
Sorry, this is Jennifer.
Oh,
I just wanted to note that because it sounds like things are creeping more into the clarifying and interpreting, that if it's not specifically within current statute or regulation, that this would be something to look into for potential regulatory or even potential statutory change.
Okay, thank you for that clarity. With that being looked at, I would suggest that we kind of take that off of the discussion today and continue it with just focusing on that itself. And if you're agreeable that we move forward with the FAQs as written, with section number 1 and number 6 being updated to take into consideration our discussion, such that the update would be available at the board meeting when we vote for it at the board meeting. Renee, I see your hand up.
Yeah, I think we talk a lot about the name here. To me, the intent here really is that the public or anybody that's not the pharmacist or technician would clearly know who they're talking to, a pharmacist or a technician, right? I mean, I think that's the really important distinction here, saying, clearly identifying them as a technician. And the only thing I would add is, I don't know if there's any more verbiage to that, or perhaps example could also have a couple pharmacist example and then also put technician in as well, instead of the example only being as a pharmacist.
What are your thoughts, others? This was just supposed to be examples of different names for one title.
Yeah, so this is Nicole. I just wanted to say, I think, yeah, if we're going to look at something statutorily or regulatory, maybe clarifying the purpose. Like if the purpose of this is just that someone can identify who that person was, can it be enough that if you went to the PIC could tell you based on the name that was given, versus that the patient needs to know the name to the extent that they could give the board the exact name to identify the person? That gets really tricky because there's multiple people with the same name, so it gets into a touchy subject. Also, if we're going to get into this into a statutory or regulatory area, we probably want to clarify or write into there if you are required to give your full name if asked, if it does not appear on your name tag, because that happens a lot. Someone will say, I want your last name. How do you spell that? Things like that. And that's always been a question for people. And going back to safety, people don't always feel safe to give their full information. So if we're going that route, I just wanted to bring up, we should clarify that or include that in where we go as well.
Those are all good points. I think we can have those discussions at a future meeting to really dive into this. So going forward, I'm looking for a motion, if you believe that the motion on the screen is appropriate, and to include consistent with the committee's discussion so that we can update number 1 and number 6.
All right, I thought Nicole made a motion already. So sorry.
Oh,
I
did
thought
you?
I seconded that. Yeah. Okay.
I said I would, but I don't think I actually read it. So I'll read the official motion if that helps. So I would like to recommend approval of the updated FAQs related to the board's Ask an Inspector program, consistent with the committee's discussion.
Second that.
Great. With a motion and second on the floor, I now open for public comment on the draft Ask the Inspector FAQs. Moderator Ann, we're ready for public comment via WebEx.
Thank you. This is the moderator. If anyone would like to make a comment, you can click on the hand icon to raise your hand. If you are on a mobile device, that raise hand icon might be behind the 3-dot other options. And if you're a call-in user, you may press *3 to comment, to request a comment. Instructions are on the screen. We have a hand raised from Andre Peters. Andre, you'll have 3 minutes with a 10-second warning, and I'll send you a request to unmute your mic. Go ahead.
Can you hear me okay?
Yes.
Thank you. Just want to point out a couple of things I've observed as I was reviewing the materials. First one is that BP's 680 requiring the name tag is not in the pharmacy law book that I could find. So I just want to point that out. It might be helpful to add it in the pharmacy law book. The other observation that I haven't seen before, but it kind of jumped out to me, and hopefully we can bring this to the attention during inspections and enforcement, is that the 18 points doesn't appear to be applicable to technicians. Because the regulation doesn't require that, and 680 says it's healthcare. It applies to healthcare practitioners. Just want to kind of point out that potential for confusion when we're dealing with licensees on the front lines. Thank you very much.
Thank you, Dr. Peters. Some interesting points.
Thank you. And I do not see any further requests for comment. Shall I close that public comment feature?
Yes, thank you.
You're welcome.
Members, any additional comments before I take a roll call vote? Okay, seeing none. Renee Barker.
Yes.
Sung Oh.
Yes.
Nicole Thibault.
Yes.
And I vote yes, motion passes. Thank you. Next item is 8, discussion and consideration of updates to frequently asked questions related to Assembly Bill 1286. Members, you may recall as a part of our discussion on implementation of Assembly Bill 1286, given the comprehensive nature of the measure, we determined that development of frequently asked questions was appropriate. The FAQs were initially approved during the February 2024 board meeting and updated again in April and November of 2024. Last year, the board approved the Institute for Safe Medical Practices as the entity to receive medication error reports from community pharmacies under BPC 4113.1. Recently, board staff have updated the FAQs to include this information, as well as additional information about the California Medication Reporting, CAMER, C-A-M-E-R, including registration and fee information for licensees. Attachment 3 includes the updated FAQs related to 1286. I've had an opportunity to review the updates and believe that they are appropriate. Members, do you have any thoughts on the draft document? And as a part of our discussion, I would appreciate a motion.
I can make a motion to approve as presented. I don't have any comments at this point.
Okay, do I have a second?
This is Nicole. I'll second.
Great, thank you. With a motion and second on the floor, I open the discussion for public comment. Moderator, we're ready for public comment via WebEx.
Thank you. This is the moderator. If anyone would like to make a comment on the discussion or the motion, you may look for the hand icon and click that to raise your hand. And instructions are on the screen. My apologies. Now instructions are on the screen, and each speaker will have 3 minutes with a 10-second warning. Are there any comments on the motion or the discussion? I do not see any request to comment. Oops, hang on. Andre Peters, I'm going to send your request to unmute, and you'll have 3 minutes with a 10-second warning. Go ahead.
Sound check?
Yes.
Thank you. When we were looking at this and the instructions that is forthcoming via email from the board, and by the way, thank you for sending that to us. It helps us stay on track with getting registered for reporting errors. Scripps Health is a health system. We have multiple types of pharmacy licenses, retail and hospital types of licenses. And it is not clear in either the statutes or on the FAQs whether we should be licensing our hospital pharmacies. The instructions between emails and FAQs are very confusing. So I'm wondering if we could clarify that as soon as possible. Thank you.
Thank you, Dr. Peters. I know that we've answered that question before, and rather than me trying to interpret it, Corinne or Anne, would you like to talk about what license categories required to register?
This is Corinne. I mean, I could direct, your attention to the first FAQ, which talks about which types of licensees are required to report medication errors, and it references the definition of community pharmacy in the statute.
Great, thank you. Any other public comment?
I do not see any further raised hands. Shall I close public comment?
Yes, thank you.
You're welcome.
Members, do you have any other comments before we take a roll call vote?
Hey, Chair Serpa, I just have one comment for you or Renee. You folks in inpatient background, is that common for a hospital pharmacy, HSP, to actually dispense outpatient in your experience? Because we have a lot of, I think, hospital folks kind of getting a little confused by this, I think, law. So just curious, is that a common practice in inpatient setting?
So there's some criteria about the number. Hospitals typically do a very small number of quote unquote discharge type of prescriptions under the HSP. And if they do any significant type of prescribing, I worked in one hospital where we had a separate PHY. So we had 2 licenses within the same pharmacy. But that's what I'm familiar with. Renee, did you have anything to add?
We have an outpatient pharmacy.
So you must do quite a few dispensing events.
Through our outpatient pharmacy.
So it varies on the pharmacies, but there are some criteria about when it's not an unusual circumstance and it becomes a usual thing. Then that's when people get a PHY. That's my experience. I'm only talking about my experience. I know that there's probably a better legal answer, but there we go.
Okay. Thanks, guys.
Okay, so I think we're ready for a roll call vote. Renee Barker?
Yes.
Feng O?
Yes.
Nicole Thibault?
Yes.
And I vote yes, motion passes. Agenda item 9 is discussion and consideration of the committee's strategic objectives. As indicated in the meeting materials, Enforcement and Compounding Committee has 11 strategic objectives. In the meeting materials include updates on these objectives, highlighting our efforts over the past year. I'm very proud of the committee accomplishments towards strategic objectives, and I'm looking forward to our continued efforts. I'd like to highlight significant progress made towards strategic goal 2.1, and that the ISMP, Institute for Safe Medication Practices, has been approved by the board as the entity to receive medication errors reports from community pharmacies under BPC 4113.1. As previously noted, medication errors that occur on or after September 1st, 2025 must be reported to the California Medication Error Reporting, or CAMER.
Chair Serpa, I'm sorry, I don't believe that this is a legally an issue, but I'm being told that they lost power at the hearing room. So that explains the blank screen on that hearing room. This weird stuff is happening.
So let's, I don't want to take a break too long because we want to finish before lunch. So let's take a 2-minute break here because we do have to make sure that our attorney is able to hear us and that they are.
Maria, this is Shelley, and I'm happy to stand in for Corinne right now.
Okay, that's great. And so I just need to find out from Debbie if she could dial in so that she could take notes.
Is there some kind of a legal requirement, Shelley, that a public location has to be available for people to be able to speak?
And as an update, they just said power came back on, so Wi-Fi may be just a moment behind that.
Okay, so we'll just kind of pause here for about 30 seconds and I'll see what part that they heard. I could actually start at the beginning, so we've only talked a couple of seconds here about this subject. But thank you for noticing that, Sung.
Oh, they texted me and I was like, oh God. So just, some weird stuff is happening.
And I think that, just for everyone's notice, I think that we'll be able to finish before lunch. And we may go a little over noon, but that way we don't have to come back after a significant break. Wait here for a second.
And it appears that a number of the attendees who had logged in from the room just disappeared from the WebEx. My apologies, and we do ask for everyone's patience while we determine next steps.
Maria, would you like to take a 5-minute break? That would be fine.
Just a moment, I'm getting a response here from the room.
Okay.
Yeah, let's take a 5-minute break and we'll come back at 11:55.
I think just so everybody can relax, I think the committee meeting for the afternoon is at 2. So we have yeah, we have some time, I believe. So.
That's
We do have
correct.
time, but I'd prefer not to have to come back so that people
Oh,
can
I
have a
agree.
really
I'm
a
with
big
you.
break.
Absolutely.
So we'll come
Yeah.
back at 11:55.
We're just Hi, this is Anne. Could you hear me?
Yes.
Perfect. Sorry, we had a power outage here, so we lost everything. We are back now. Thank you for your patience.
I just have one question for you, and then when we go back on the record, I'll ask you again. But what part did you hear? What was the last thing you heard? Did you hear the vote?
So we have that the motion passed.
Okay, good. So then I'll just start back a minute and with this number 9. So we took a break. So we're coming back in 1 minute at 11:55. We'll come back and restart. Thank goodness.
Hey, Maria, for some reason you are blank on my end. I don't know if it's just me.
Oh, maybe I forgot to click my button.
Oh, there you are.
I thought I saw myself for a minute, but okay, it's 11:55, and thank you everyone for your patience as we are coming back from a short break. Let me take a roll call to confirm everyone is here. Renee Barker.
Present.
Sung Oh.
Present.
Nicole Tebow.
Present.
And I'm here also. We took a quick break because of a technological difficulty in the hearing room, and they lost contact with us after we completed agenda item 8 and we had the vote. Can someone in the meeting room confirm that what the last thing you heard was and your status?
This is Anne. We heard the vote on the approval of the FAQs related to 1286. Thank you.
Great, thank you. Therefore, I will back up a minute or so and start the discussion again with agenda item 9, discussion and consideration of the committee's strategic objectives. As indicated in the meeting materials, the Enforcement and Compounding Committee has 11 strategic objectives. The meeting materials include updates on the objectives, highlighting our efforts over the past year. I'm very proud of what the committee has accomplished towards these strategic objectives, and I look forward to our continued efforts. I'd like to highlight the significant progress made towards strategic objective 2.1. The ISMP, Institute for Safe Medication Practices, has been approved by the board as the entity to receive medication error reports from community pharmacies under BPC 4113.1. As previously noted, the medication errors that occur on or after September 1st, 2025 must be reported to the California Medication Error Reporting, or CAMER. I'd like to also acknowledge the progress staff have made towards meeting strategic objective 2.3. Inspectors have done a fantastic work in accomplishing the board's 4-year goal. As we previously talked about, it was a tremendous effort. It's my understanding that the board has also assigned approximately 1,550 routine inspections last week towards continuing pursuing this strategic objective. I'd also like to acknowledge progress made towards strategic goal 2.4. Proposed amendments to BPC sections 4081 and 4105 are included in the board's sunset measure, AB 1503. In addition, the board's implemented a new digital process to streamline the investigative process and reduce investigation timeframes. The committee has been working on strategic goal 2.5 for several years. The board is proud to report that provisions to transition pharmacist practice to a more robust standard of care practice model are included in the board's sunset measure, AB 1503. For strategic goal 2.8, the board implemented a new learning management system for licensees to complete board-provided continuing education, including newly required PIC training course. Our work related to strategic objective 2.10 resulted in 5 formal comment periods, a regulatory hearing, an extensive review and discussion over the course of multiple public meetings. As you recall, the board approved final regulatory text in March of 2025 and thereafter submitted the final rulemaking file to OAL. I'm very proud of the work that the committee has completed and truly appreciate all the engagement we received from interested parties. You will note that we added strategic objective 2.11 regarding evaluating barriers to consultation in November of 2024. This area continues to be a challenge, as we heard earlier in the meeting today, and I look forward to the committee discussing this issue in a future meeting. Members, do you have any thoughts on the strategic objectives?
I just have one comment, Chair Serpa, on the standard of care 2.5. It says completed. I don't want to be superstitious. I don't want to jinx it. We still have a lot of work. I think maybe it's intended to say that the board work is completed, but we still have a lot of work this year. So it's very close, but I don't want to put completed yet. So
I think it's talking about the committee's work is completed.
oh, yes, that's what I figured, but
Okay. Yeah, the board still has a lot of work to do, but the committee's
yeah,
work
and the
is completed.
legislator. Yeah, okay.
Any other comments? Okay, seeing none, we're ready for public comment via WebEx.
Sorry, I thought I unmuted myself.
Sorry.
I think I
Go ahead, Renee.
unmuted and muted. So sorry. No, I just wanted to sort of call out 2.6, the establish greater consistency in how inspectors interpret the law and carry out inspections. And I think that this work is important, which is why it was a strategic objective, but also seems to be effective, as we saw in the inspections, the report that we got, looking at decreases in findings. So anyway, I think it's really a great process. I'm sure it's adding to their workload, but I do think that it's just really that this is important and going well. So I just wanted to say thanks.
Great, thank you. Okay, and without any other comments, I think we're ready for public comment via WebEx. Moderator, Ann?
Thank you. This is the moderator, and if anyone would like to make a comment on any of the strategic objectives, you may look for the hand icon at the bottom of your WebEx screen, and our call-in users can press *3. Each speaker will have 3 minutes with a 10-second warning, and we ask people to speak only once per agenda item. And are there any comments on the strategic objectives? I do not see any requests for comment. Shall I close the public comment period?
Yes, thank you.
You're welcome.
Members, do you have any additional comments before we go on to the next agenda item? Seeing none, we're going to go quickly, not too quickly because this is an important issue. Agenda item 10, discussion, consideration, and possible action on the proposal to add new section 170751 related to accessible prescription drug labels to Article 2 of Division 17 of Title 16 of the California Code of Regulations. Members, you may recall that during our October 2024 meeting, the committee discussed possible implementation activities for a number of measures signed by the governor, including AB 1902, a measure related to prescription drug label accessibility. During the committee's March 27, 2025 meeting, various policy questions were considered. The committee agreed that the board's regulations in this area should focus on ensuring pharmacies develop policies and procedures to define how compliance with legislation could be achieved. During subsequent discussions at the April 2025 board meeting, board members spoke in support of the recommended approach. Attachment 4 includes draft regulation text for our consideration today. I had an opportunity to review the draft regulation language and believe it's representative of our direction to staff. Members, I welcome your feedback and any comments on the regulation draft. And after discussion, should you believe it appropriate, I would appreciate a motion as displayed on the slide if that works for you. Members, any comments?
Go ahead, Sung.
Okay, thanks, Nicole. No, I just wanted to say that I think this is very in line with the discussion and the direction that we were hoping for. So I appreciate the work. I do support it. Again, this is a regulatory path. It's a long road. So I am happy to make a motion, but I will but I'll let others speak before I go ahead. So
Yeah, I agree that what we put together was inconsistent with our discussion. I'm a little confused about this regulation overall, or what has to happen with this. So I have to imagine that the regulated public is as well. I'm confused as to whether a spoken label or like a verbal label will meet the requirements, because as I'm looking at what's written in our agenda, not the attachment, but in the original part, it seems to say like it has to be like a label, but not everyone can use Braille and size to get that all on there. So I thought like a spoken label was going to work and was probably going to be a better option for a lot of people, but this kind of sounds like that doesn't work. So I kind of feel like I need more understanding about this. I don't know if everyone else is in the same place, but I'm confused.
absolutely. I
So-
completely agree with you, Nicole. That's
Okay.
always, yeah.
So to give you some background, because it really is very deep, I was so pleased to work with staff and our attorney on the different ways that this regulation was written, because the ideal was that the pharmacy would develop their own policies and procedures and would not be limited in regulation to the technology of today, because who knows what the technology of tomorrow is. So all of that was not specific in here. It does talk about also one thing about accessible labels. I'm trying to find it. Okay, so number 3, that's the big important part, is this is describe the process used to determine the patient's accessibility needs. That's one, that's on your policy, you'd have a process. List the accessibility options, so that's 2, you would have a list of options that's available in your pharmacy. And include any deviations on the labeling requirements. So you could have deviations to the labeling requirements. You just need to include that in your policy to explain what those deviations are. So we didn't get into the weeds. We leave that to every site to determine how they would determine what the patient needs, what options they provide, and if such options require a deviation from the laws that talk about what's required in the label, they need to explain that. So hopefully that helps a little bit. But I can see an FAQ would be helpful too, because in the FAQ, we could provide some more examples, but in the regulation, we were purposely broad and open because this is an area that's going to be changing quickly. Technology changes quickly.
Hi,
Yeah,
this is Jennifer.
Oh, go ahead, Jennifer.
Sorry to interrupt again. Just wanted to note that the regulation would implement, interpret, and make specific the statute, which speaks specifically to labels written that would be either affixed to the container, or if it can't be affixed to the container, there would be a supplemental document that we provided. So this specific statute speaks to some form of a document and written version. And so the regulation would be specific to that written version as well. So, and it would be required that there be a written version, but the pharmacy, if they choose, could go further in other versions that are not specifically required.
Okay, I'm sorry. I didn't want to go this today because it's I think long road ahead, but and then there's a little time constraint, but since we're talking about it, I just want to throw out like this is how I think of real world scenario, right? So let's say a person who is blind but also have hearing impairment, and let's say that this person requests it be Braille, but then the pharmacy has only capability to provide a audible bottle. in that case, that person files a complaint to the board. What is the consequences through the layers of the legislation and the regulation? What is the outcome, right? That's kind of what I'm thinking through. And so if a pharmacy, because the statute says appropriate to the disability and language of the person making the request through the use of audible, large print, braille, or translated directions as required pursuant to section 4076.6. So, that's the part where I think a lot of regulated public would be confused. With that said, I think that this regulation, as you addressed, Maria, is number 3. I think that addresses it. And my hope is that, a pharmacy making a conscientious attempt to have a way to provide some way to accommodate those people is going to meet the requirement. That's the point I'm making, not to provide further clarification, is that I would hope that a pharmacy is not expected to then somehow magically come up with a braille service, because they only can provide is the spoken bottle, because all these cost extremely large amounts of money, like at least $10,000 a year, at least. So, I just want to put that out there.
No, that's a really good point, because it actually, we've had a little bit of discussion about that in another situation too. And so 2 is supposed to help cover that too, because the important thing is that the patient receive their medication in a timely manner. So what does that mean will be determined by the pharmacy's policies and procedures. Timely manner may mean that they send them to the pharmacy down the street. Timely manner may mean that, the example that I gave in our discussions was antibiotic, but it's going to take me 24 hours to get an accessible label. So maybe in my discussion with the patient, I give them a day's worth of medications in a quote unquote non-accessible format, but the remainder or the next refill or whatever is in their policy and procedure is an accessible format. Because we also want to make sure that it's timely manner for convenience, but also timely manner for patient clinical needs. You can't tell a person who needs an antibiotic, oh, that's going to take me 2, 3, 4 days. That's not appropriate for the patient's condition. So again, that was another reason why it was written in this way, because pharmacies are going to know what they have access to. And rather than have the board dictate to them, we just wanted to provide the patient safety parameters, I guess you could say. I'm trying to think of the word that goes around the bigger picture, and that each pharmacy would determine how they would do that to assure patient access, patient is included in the discussion, and that they have clinically received their medications in a timely manner. But those are all really good discussions, and I think that we were going to hear also from members of the public, because it really puts the ball back on their court as to determine those answers, because every place is going to be a little bit different.
I will just comment that I appreciate what you laid out there, Maria, and that really exactly is where I'm hoping we go. So thank you. That's very helpful.
But I do see that we need some FAQs, because being a pharmacist, and all of us who happen to be on the committee today are all pharmacists, is we like to know everything in black and white. But often that can be our own worst enemy, to have something in regulation that is not wiggle, that does not give us any interpretation. So this hopefully provides what's best for patient safety and access. And FAQs, I think, would be helpful, including these discussions that we have at the board meeting too next week. Will probably bring up some more questions. So do we have a motion? Oh, sorry. Yeah, do I have a motion? I do need a motion.
I am more than happy to make a motion to recommend initiation of a rulemaking to add California Code of Regulation Title 16, Section 1707.51. I think it wouldn't harm us to say consistent with the committee's discussion, although there is not any identified changes per se. But I will just say that, and authorize the executive officer to further refine the language consistent with the committee's discussion and make any non-substantive changes prior to presenting the proposed rulemaking to the board.
Thank you. Have a second?
This is Nicole. I'll second.
Thank you. With the motion and second on the floor, I now open the discussion to public comment on the draft regulation. Is there any public comment on WebEx?
This is the moderator. If anyone would like to make a comment on the draft regulation, you may look for the hand icon and click that to raise your hand. And our call-in users can press *3 to raise their hand. Instructions are on the screen. Are there any comments on the draft regulation? I do not see any requests for comment. Oh, hang on. Andre Peters, let me send you a request to unmute. You'll have 3 minutes with a 10-second warning. Hey, go ahead.
Hi, thank you for the opportunity to comment again. I'd like to maybe ask this committee to consider the removal of subsection B, which says that pharmacy personnel must read and sign a copy, and the signed copy to be maintained. I think we all agree that this is a very small record-keeping requirement, and on itself is quite doable. We always have to also look at the administrative burden that we place on licensees. And, unfortunately, this has been pointed out many times in the past, and I'll probably continue to point this out, is every little bit of administrative burden we add takes pharmacists and pharmacy technicians and pharmacy staff away from direct patient care. And it's literally a case of death by 1,000 cuts. We generally, except maybe for compounding regulations and statutes, generally don't see the requirement to for this for policies and procedures in the pharmacy. And it's a small thing, and hopefully a small ask if we would consider removing that. The expectation is always that if we specify policies and procedures and we put it in writing, that it will be followed. Nothing wrong with that. But I just want to ask, please consider removing that and keep us as pharmacists close to patients where we belong and we have the greatest impact versus burdening us with more and more administrative duties all the time. Thank you.
Thank you, Dr. Peters. And, I don't disagree with you. I think that the challenge to me was during the board's discussion, that was their direction to us to assure that patients had accessibility. I'd be interested to see what the other members have to say, but I think the concern was that a patient would talk to a frontline person in the pharmacy who'd be unfamiliar with all the different technology and would be told, oh, no, sorry, you can't have that. And that wouldn't go any further and would be a barrier to accessibility. But members, what do you think about the comment made by members of the public? Oh, sorry, we haven't finished public comment. I jumped ahead. Sorry, is there any other public comment?
I do not see any further requests. Shall I close that feature?
Thank you. Sorry
You're
about that. I think that, sorry about that. I jumped ahead. So members, do you have any comments? Renee's hand was up first.
Hi, yes, I think that's a really great point by Dr. Peters. I would say that, in terms of policies and procedures in any pharmacy, everybody's required to follow them. I mean, if there's a training issue or gap with the staff, I think that's different than, couldn't be addressed. But I do think that having like a requirement for this particular signing of this particular policy in a very narrow scope, I think is really challenging. I think, and actually probably, honestly, I would agree with him, not necessary in the fact that this would just need to be incorporated into training and policy and procedure review on initial hire and, sort of annual review of policies. And as he mentioned, I mean, the compounding policies are very strictly reviewed by staff and have to be documented as required by USP. But I just feel like there's, many different nuances going on in a pharmacy, and there's not always the like policy and procedure documentation. You might have a training, an update, and have an acknowledgement that they've completed some kind of training. But I do think in terms of having it be, a regulatory requirement, I would agree with not including that.
Thank you. Sung, I saw your hand up.
Thank you, Maria. So I am going to give some, I don't want to say wishy-washy, but I am indifferent. So, and the reason is, so I see two sides. I completely understand. And I think that anytime we require something like this in a regulation or statute, the thing is that it just turns into just another thing to check off, and nobody really listens anyway, or really takes, into consideration. So, like Medicare fraud, waste, and abuse, how many of those we have watched in the pharmacy for many years that is very serious, but it just became a thing to do, right? So, so many other examples of that is just another thing to do. So I completely understand and hear Dr. Peters, and I am more than happy to be amenable to changing the motion to, well, I guess I don't need to change the motion because we are continuing this discussion. So I think this is enough. Now, though, I would like to give another perspective as a PIC is, though, I think that if someone actually attests to doing something and they sign a document, which I would imagine that this is electronically is acceptable, because everything electronic is acceptable. As a PIC who's not on site at all times, which is very common, I cannot be there. Sometimes I joke I live there, but I don't live there, because we can't, but we are responsible for, right? So I always think of scenario where what if somebody comes, requested an accessible label, I wasn't there. This, I think, could be used for me, at least from my perspective, is a mitigation for my license as a PIC. So I would like to provide that perspective of why I'm also would be okay to having some kind of attestation, because they were trained to do this and there is a record. And as a PIC, I feel much comfortable. And if it turns out they didn't, they file a complaint with the board, my mitigation is that my staff acknowledged they signed this and they should have known that this was a requirement under the law and the regulations. So that's another side to it. Again, I'm okay removing at this point, but I would like to just provide you, for all those regulated public, all those hardworking PICs and the compliance officers out there, I understand that, it's an inconvenience, but also there is a flip side to always, right? There is a side of it where it can actually assist you in the long run in terms of you being compliant and keeping the record of all the things that we do, that we held all of our staff to be accountable, because this is the way, though, to hold our staff accountable and to say that we have really tried to educate. And so that becomes that person's, right, responsibility, not the responsibility automatically that falls on the PIC. Long-winded answer of non-answer, but just wanted to provide some perspectives.
I muted myself. So where we are now is we do have a motion on the table and have heard discussion regarding an alternative. If there's no further discussion, we could either vote to this down and come up with a new motion, or vote to approve and continue the discussion at the board meeting. I think unless you have any other comments, we're ready for a vote.
Point of clarification for Jennifer and Anne. since the motion is I said is consistent with the committee's discussion, do we need a new motion?
No, the motion was sufficient.
I'm not
Right.
sure we come to then we need to have more discussion to have a consensus. I heard you would go either way, removing B. Renee suggests removing B. Nicole, do we have a consensus on what your preference is for B?
I can go either way. Sorry, I'm not helpful.
Yeah.
Can I just also add that I feel that number 4, A4, describes the training, part of the policy and procedure describes the training provided to pharmacy personnel. So there would be some, documentation that you have it in your training, which is usually documented anyway. So perhaps this B might actually be somewhat duplicative.
So
I'm gonna change my vote. I'm gonna go with Renee's initial that we probably should include B, and the reason being that we want to make sure people are taking that step just to think about it. It's very often that when disabilities are involved, we just kind of meet the requirements, but we don't actually think about what the person needs on an individual level. So I think including asking people to make that assessment guarantees that we're at least thinking about it, because it can be different for different people. So I'm gonna go with that. We should include it.
So I'm hearing.
That's up to you, Chair Sarbadang, because I'm staying.
Well, I'm hearing that the committee's consensus is our discussion is that we leave it in. We had it looks like we don't have a consensus, and so we can still have this discussion at the board meeting. I think that'd be another opportunity for us to have more discussion on this and more public comment on it. But I don't feel like we have a clear consensus to take it out. Although Sung's motion was about consistent with the committee's discussion. And at this point, I don't think the committee has a consensus. Is that what you all agree? Renee?
I guess, sorry if I wasn't clear. I'm not sure based on Nicole's recent comment. I was actually sort of proposing that we strike B in terms of signing the policies and procedures, and go with that we have 4, which we describe the training, which describing training describes what the training is and that you've received the training. So to me, that is probably means that it's documented somewhere.
Right. So
as
that's
opposed
what I
to
heard.
the policy.
So just to summarize what I've heard, Renee is suggesting removing B. Nicole is suggesting we leave B. Sung says he can go either way. And my suggestion, I guess, to just kind of summarize is that we leave it in, and we don't have a consensus because everyone has different opinions, and that you have an opportunity with the full board to restate your opinion so that we could have more voices. How's that? Okay, so we're ready to move to the vote. And we don't need public comment again because the motion did not change. Thank you, Sung, for reminding me of that. Renee Barker.
So I'm saying yes with all of what you just said, right? For more further discussion, correct?
Well, we're going to be sending it to the board as is, and then you could discuss it there. So the motion is as written on here.
Okay, yes.
Okay. Sung Oh.
Yes, it's a long road, so yes.
Nicole Thibault.
Yes.
And I vote yes, motion passes. Thank you all. I think I'm looking forward to the discussion next week. Agenda item 11, discussion and consideration of enforcement statistics. The meeting materials include a summary of enforcement statistics for the first 11 months of fiscal year 24-25. The board initiated 2,850 complaints and closed 2,597 investigations. As of May 31st, 2025, the board has 1,582 field investigations pending. The materials provide a breakdown of the average time frame for the various stages of the field investigation process. Members, do you have any thoughts or comments on the statistics? Seeing none, I'm ready for public comment via WebEx.
This is the moderator. If anyone would like to make a comment on the enforcement statistics, you may look for the hand icon and click that to raise your hand. If you are a call-in user, you may press *3 to raise your hand. Each speaker will have 3 minutes with a 10-second warning. Are there any requests to comment on the enforcement statistics? I do not see any requests for comment. Shall I close that feature?
Yes, thank you.
You're welcome.
Thank you, everyone, for your time and consideration today. We're on agenda item 12, future meeting dates and adjournment. As we adjourn today, I'd like to thank you all for your time and participation. Our next meeting is currently scheduled for October 16th, 2025. Please monitor the board's website for updates. And as a reminder, there are dates for the full board meeting coming up also. The meeting is adjourned. Thank you.
Thank you.
Thank you.
Thank you, everybody.
Thank you, everyone.